Yes, Amit ji, now you can start.
Yeah, please. Manoj, should I start?
Yes, I requested you already. Please start.
So, good afternoon, friends. Welcome to this series of webinars of All India Insolvency Professional Association. This virtual program is being organized in association with the Chartered Accountant Association, Jalandhar, Kerala Insolvency Professional Forum, Kochi, NCLT, Kolkata Bar Association, and Association of Practicing Cost Accountants, New Delhi, and JIPA Professional Association, New Delhi, MSME Development Forum, West Bengal. So welcome to all the peer associations to this program, wherein we are essentially going to deliberate on two important aspects, wherein our President, Mr. Manoj Anand, will first apprise us with the latest development with regard to the changes which are in cards and the issues of the insolvency professionals. And then they have the eminent speaker, Mr. Nipun Singhvi, who will be making a deliberation on the Prevention of Money Laundering Act, which has been a matter of concern for quite a while since the notification that was issued by the Ministry of Finance on 3rd of May 2023, and then later on another notification on 9th of May 2023. So a lot of questions are there. I'll just say keep your questions ready. Post it on your chat box. We'll take up all the questions, and we can assure it is going to be a very, very enlightening innovation in today's session. Without any further wait, I'll pray to Manojji to take the session forward and apprise us with the development with regard to the insolvency and bankruptcy code, and especially the issues with regard to the insolvency professional. Over to Manojji.
Thank you, Amit ji. Thank you very much. Amit ji, थोड़ी सी आपकी इंटरनेट में शायद कोई दिक्कत आ रही है. वो चैट बॉक्स में कहा कि आपकी आवाज काफी ब्रेक हो रही है, तो थोड़ा सा जरा इम्प्रूव करना. I welcome Nipun ji. His video was just visible, but he is coming back. Nipun ji, आपका वेलकम, बहुत बहुत धन्यवाद.
Thank you very much, sir. I am very much here only, sir.
मैं इनफैक्ट अपने बाकी पार्टिसिपेंट्स को भी कहूंगा कि वो अपना वीडियो ऑन कर ले, बिकॉज जब आपका वीडियो ऑन होता है तो ऐसा लगता है कि हम फैमिली की तरह मिलके सब लोग मिलजुल के बात कर रहे हैं. अखिल जी, थैंक यू वेरी मच, एंड रिक्वेस्ट एवरीवन एल्स आल्सो. श्रीनिवास जी ने भी ऑन करा है. दैट्स रियली ग्रेट कि यू नो व्हेन वी टॉक टुगेदर तो फिर ऐसा लगता है कि हम आपस में मिलजुल के बात कर रहे हैं, जैसे सिटिंग इन अ ड्राइंग रूम और सिटिंग इन द ऑफिस एंड चैटिंग लाइक दैट. थैंक यू वेरी मच. लॉट ऑफ पीपल आर नाउ ऑनिंग देयर वीडियो. और चलिए, तो अमित जी, आप प्लीज थोड़ा सा निपुण जी का, हमारे जो आज के गेस्ट ऑफ ऑनर हैं, इनका थोड़ा सा ब्रीफ इंट्रोडक्शन दीजिए, और देन आई मूव फॉर माय प्रेजेंटेशन.
Yeah, I know Nikunji don't need any introduction. He is a stalwart in his own field. but definitely it's my duty to introduce you with all our IPA members and the other fellow associations. So Nipunji is practicing as an advocate. He's a fellow member of the Chartered Accountant Institute, communicatory law graduate. In fact, masters he hold in the law. He's a certified forensic IFRS bank auditor, qualified independent director from the Ministry of Corporate Affairs. He is done with the executive program on the merger and acquisition from the Indian Institute of Ahmedabad. He is a qualified insolvency professional, and he has been trained by the World Bank for the purpose of train the trainer program, which was organized by IBC-IP. And he has been part of various committees of ICI on the corporate law, bank audit, accounting standards. He has been contributed to the WIRC reference manual on insolvency law and a guide to IBC by Bloomsbury 2021 edition. Taxman Gujarat RERA manual. He has been a resource person for ITI certification course on drafting, appearance, and reading, and ITI certification course on MSME, and also on certification on insolvency and bankruptcy board examination. He has been awarded Divya Bhaskar Award, excellent contribution to the real estate. He has delivered innumerable lectures. What I'm told, he has delivered more than 1,500 lectures of the various cities. He has been a regular faculty to the Institute of Accountant, Ministry, Bank, CAG, Trade Association, and wherever you talk about the word solvency, he has been associated, and he has been involved in more than the debt resolution for 1 lakh crore rupees, and including the all important cases, whether it is JP Infratech, Lamco, SR Oil, SR Shipping, Swiss Liman, Reliance, Naval Engineering, Gujarat Ambuja, Syntax Engineering, ABG Shipyard, Digdam, Today's Writing, Ray Rayon, and Gopala Polyplast, to name a few. He has been a financial activist. He has filed various PIL, the public interest, and he has been a social activist also. He has been a RTI activist also. So welcome Nikunji to IPA, and we all are anxiously waiting for your deliberation in the today's program. Welcome you, sir.
Thank you very much, Amit ji.
चलिए निपुण जी हमारे वो कहते हैं ना कि जैसे सूरज हैं हमारे प्रोफेशन के अंदर, हमारे आईबीसी के अंदर, जब भी कोई इंट्रिकेट प्रॉब्लम आती है, कुछ बड़ा एक ऐसा इशू आता है कि वेयर बाय वी नीड टू लर्न, इनफैक्ट एज फार एज पर्सनल इंसॉल्वेंसी लॉ इज कंसर्न्ड, व्हेन इट केम इनटू द रियल प्रैक्टिस अ ईयर अगो आफ्टर ललित कुमार जैन्स केस, we were having a very good interaction. In fact, I learned a lot from him also during deliberation with our honorable NCLT, the members in Giba's webinar. In any case, we are really thankful that he is sparing his time to give to us. चलिए, जैसा कि हमारा यहाँ पे ट्रेडिशन है, हम आईपा के अंदर हम लोग क्या कहते हैं, हमेशा स्टार्ट करते हैं अपडेट्स की. तो लेट मी शेयर माय स्क्रीन फर्स्ट and then we can go for it. Please just wait for a while. I just share my screen. ओके, हमारा लास्ट वेबिनार हुआ था 21/5/2023 को, और आज है 10 जून सैटरडे 2023। तो इसके बीच में जो भी हमारे अपडेट्स हैं तो वो मैं आपके साथ शेयर कर रहा हूँ। First of all, I start with the proverb. We are having a CA day on July 1st. I think before that we shall have another 1 or 2 webinars. But even then, I wish in advance to my all CA colleagues and other professional colleagues also. Excellence is never an accident. It is always a result of high intention, sincere efforts, and intelligent execution. It represents the wise choice of many alternatives. Choice, not chance, determines your destiny. तो हम भी जो अपनी मेहनत करते हैं आईपी के केसेस के अंदर, दीज आर द फ्यू लाइंस व्हिच आई हैव चूजन फॉर वी प्रोफेशनल्स, आईपी प्रोफेशनल्स, and in fact in our other practice also, maybe that is of the advocacy or maybe of CA, CMA or CS practice. तो मेरा सबसे पहला, देखिए इसके अंदर जो मेरा पहला अपडेट है वो है क्या नाम, पीएनबी की एम्पैनलमेंट के बारे में। तो इसके बारे में मैं जरा आपको अपडेट कर दूं। ये जो लिंक मैंने जो है चैट बॉक्स में, ये मेरी जो वर्ड फाइल है मैंने शेयर कर ली है, तो आप उसको डाउनलोड कर लीजिए। और जहां जहां का जो लिंक ये अभी आपको मेरी स्क्रीन पे नजर आ रहा है, ये जब वहां पे आप क्लिक करेंगे तो कर लेंगे। आईपीएस के लिए पीएनबी इज द सेकंड लार्जेस्ट बैंक आफ्टर एसबीआई, तो वी ऑल मस्ट अप्लाई फॉर दैट। आई थिंक ये 12 तारीख को इसकी लास्ट डेट है। इट्स अ वेरी बल्की एप्लीकेशन। जब हम लोगों ने भी अपनी ऑफिस में फाइल करती तो 2 दिन लग गए थे सारे डॉक्यूमेंट्स तैयार करने में, उनको करने में, ध्यान से करने में। तो अगर आप लोगों ने फाइल कर दी है तो वेल एंड गुड, नहीं करी तो प्लीज फिल इट अप। और फिजिकली हमने इसको क्या कहते हैं सबमिट करा था हमारे यहाँ पे दिल्ली के अंदर जो है ये बीकाजी कॉमर पैलेस में इनका ऑफिस है, वहां पे हमने इनको सबमिट करा था। तो इट हैज टू बी ए जोन वाइज। तो इट इज जस्ट रिमाइंडर फ्रॉम माय साइड कि आप प्लीज जरा जो भी है इसको कर दीजिए। माय नेक्स्ट अपडेट इज, I think my video has gone off. Let me, we aspire to be IP, लेकिन हमारे वो आईपीएस के ऊपर हमारे जजेस होते हैं। तो एनसीएलटी ने फिर वैकेंसीज निकाली है एनसीएलटी जजेस के लिए, 3 जुडिशियल मेंबर्स के लिए, 2 टेक्निकल मेंबर्स के लिए। इनका लिंकेज मैंने आपको दे दिया है। ये 3 जुडिशियल मेंबर्स के लिए एनसीएलटी में है। लास्ट डेट इसकी 5 जुलाई है। और क्या नाम इसका, एनसीएलटी ने जो निकाली है वो है 5 जुडिशियल मेंबर्स के लिए और 5 जुडिशियल एंड टेक्निकल मेंबर्स के लिए। तो इसकी लास्ट डेट 19 जुलाई है। इनके लिंकेज मैंने दे दिया है, चैट बॉक्स में मैंने ऑलरेडी ये शेयर कर दिया है, तो यू कैन प्लीज टेक केयर ऑफ दिस थिंग। थर्ड, एक एमसीए ने और वैकेंसी निकाली हुई है फॉर वेरियस कॉन्ट्रेक्चुअल पोजीशन इन द इंडियन इंस्टीट्यूट ऑफ कॉर्पोरेट अफेयर्स मनेसर के अंदर, जिसकी सैलरी 1.25 लाख से लेके 30,000 तक है। तो इसकी लास्ट डेट 23 से है। तो इफ एनीवन फ्रॉम योर स्टाफ इज इंटरेस्टेड तो प्लीज यूज दिस प्लेटफॉर्म टू अप्लाई फॉर दैट। और these are the small staff vacancies. Okay. Now let me come to my थर्ड पॉइंट। हमारे अपडेट ये है कि हमने आईपा की मेंबरशिप खोली हुई है। तो हमने जो आईपा की मेंबरशिप खोली हुई है उसके अंदर वी आर गेटिंग रिस्पांस, वेरी गुड रिस्पांस। जैसे हमारे निपुण जी ने भी हमारे को ज्वाइन करा है, और इसी तरह से ये श्री पीपी चौधरी जी है जो मेंबर ऑफ पार्लियामेंट सीनियर एडवोकेट है, इनको भी हमने एज एन ऑनररी मेंबर लिया है। सिमिलरली वी आर टेकिंग सम मोर डिग्निटरीज आल्सो देयर इन। तो ये जो है आई रिक्वेस्ट एवरीबॉडी टू ज्वाइन दिस। मैं एक आपके लिए फॉर्म खोल देता हूँ, इसके अंदर जो जुड़ी चीज है वो आपके साथ शेयर कर देता हूँ। तो आई रिक्वेस्ट एवरीबॉडी टू बिकम आवर मेंबर ओनली। 50th June is the last date. We may extend it as per the consensus of our governing body, but अभी आज की डेट में इसकी 15th June is the last date. तो I request everybody to apply for that. तो इसके अंदर फॉर्म जो है ये यूजुअल फॉर्म है, इसके अंदर कोई खास नहीं है। तो ऑनलाइन आपको फाइलिंग करनी है, और जो फीस है ज्वाइन करने के लिए बैंक अकाउंट की डिटेल हमने आपको दे रखी है। मेंबरशिप टाइप अमाउंट, इसके अंदर आप जाएंगे तो वी आर ऑफरिंग 2 टाइप्स ऑफ मेंबरशिप। One is for 2 years, 5,000, which will end on 31st March 2025. Second is 5-year membership of 10,000, which will end on 31st March 2018. तो ये आपको भर के इसके अंदर देना है। तो उसके बाद फिर हम आपको जो भी है मेंबरशिप वगैरह के लिए एनरोल करेंगे आफ्टर कंसिडरिंग ऑल द थिंग्स। तो ये हमारी एक छोटी सी गवर्निंग बॉडी मेंबर्स की लिस्ट है। तो दैट यू कैन सी टू इट। और एक दिस इज देयर, ओके। तो दिस इज स्मॉल थिंग। अमित जी भी हैं, मैं भी हूँ, ममता जी भी ज्वाइन कर लेंगे, नीलेश जी भी हैं, एंड एवरीबॉडी इज देयर। और एक थोड़ा सा कंफ्यूजन ये आ रहा था कि बहुत सारे लोग ये कह रहे थे कि हमने जब 2017 में अपनी आईपा की मेंबरशिप स्टार्ट करी थी, तो उस समय हमने अप्लाई करा था या नहीं करा था। तो उनके लिए जो हमारे पास, हमने उस समय दो तरह की मेंबरशिप रखी थी। एक हमने लाइव मेंबरशिप रखी थी और एक हमने एनुअल मेंबरशिप रखी थी। तो अब लाइव मेंबरशिप इस बारी नहीं है, ये सिर्फ हम जो हमारे अर्ली बर्ड वाले जो शुरू शुरू में हमारे साथ आ गए उन्हीं को मिली है। और ये जो वाली जो मेंबरशिप है, ये अब जो है ये सिर्फ क्या कहते हैं 2 साल या 5 साल के लिए है। तो इसके लिए जो हमारे लाइव मेंबर्स हैं, so that if anybody is applying, he can check it out there कि whether he is a member there or not। तो उसकी भी लिस्ट हमने ये गूगल ड्राइव के अंदर रखी हुई है। तो ये मैं आपके साथ अल्फाबेटिकली लिस्ट है ये। So before applying, you can check it from there also, so that if you are already member, then there is no need to apply for that. Or in the days to come, we are going to have lot of activity, और most probably जैसे काफी कुछ वर्चुअल हो गया है, वर्चुअल से खत्म हो गया, तो हम अब फिजिकल मीटिंग्स भी करेंगे, मे बी इन डिफरेंट पार्ट्स ऑफ द कंट्री, स्टार्टिंग फ्रॉम दिल्ली and Calcutta, and then क्या कहते हैं मुंबई also, and as per activity also। और दूसरा ये है कि जैसे जैसे हमारी मेंबरशिप बढ़ती जा रही है, तो हम लोग कुछ रीजनल हेड्स भी अपने अंदर लेंगे अदर देन एग्जीक्यूटिव मेंबर्स। तो आई रिक्वेस्ट एवरीबॉडी टू जॉइन अस, बिकॉज एक यही शायद हमारी एसोसिएशन है जो इतना एक्टिवली पार्टिसिपेट कर रही है आईपीएस की एक्टिविटी के लिए। और रेगुलरली हम लोग काम कर रहे हैं, और हर क्या कहते हैं 15-20 दिन में हम एक वेबिनार करते हैं, बिल्कुल जो एक्सक्लूसिवली आईपीएस से रिलेटेड है। तो आई रिक्वेस्ट एवरीबॉडी टू ज्वाइन बिफोर 15th ऑफ जून, और दैट इज ऑल। एंड इन द डेज टू कम जो भी हमारी टॉप डिग्नेटरीज हमारे साथ जुड़ रही हैं, तो फिजिकल मीटिंग्स के अंदर वी ऑल शैल हैव द अपॉर्चुनिटी ऑफ मीटिंग टू देम आल्सो। शायद इससे पहले अगर कुछ लोगों ने देखा होगा, तो इनफैक्ट जब ये हमारा ये वेबिनार खत्म हो जाएगा, तो हमारी जो पास्ट एक्टिविटीज अभी तक हमने जो करी है, किन यानी कि एनसीएलटी चेयरमैन के साथ, एनसीएलटी मेंबर्स के साथ, मिनिस्टर्स के साथ, मिनिस्ट्री ऑफ कॉर्पोरेट अफेयर्स के अंदर किन किन के साथ क्या क्या कर रहा है, तो उसका एक ट्रेजर सा बनाया हुआ है हमने। तो वो भी व्हेन आवर वेबिनार विल एंड, तो उसकी हम स्लाइड्स यहाँ पे लगा देंगे, तो यू कैन लुक इनटू इट। चलिए आगे हमारा फोर्थ पॉइंट है, फोर्थ माय अपडेट इज that IBBI dated 7 June 2023 has come out with 2 discussion papers. Discussion papers on measures for increasing the possibility of resolution, value of resolution plan, and enabling timely resolution. इसके बारे में मैंने डिटेल में स्टडी नहीं करी है, लेकिन इन आर सीए वोटिंग पैटर्न वी हैव, जैसे हम कैटेगरी वाइज वोट देते हैं, कि यानी कि अगर सपोज कर लो 12 कैंडिडेट खड़े, तो 12 कैंडिडेट्स को 12 वोट देते हैं इन ऑर्डर ऑफ प्रेफरेंस। जिसको हाईएस्ट नंबर पे देते हैं उसको 1 लिखते हैं, दूसरे को 2 लिखते हैं, तीसरे को 3 लिखते हैं, लाइक दैट करके। तो शायद रेजोल्यूशन प्लान को पास करने के लिए भी कुछ इस तरह की इसके अंदर प्रपोजल है। Let's see, we shall Amit ji, you please note it down. We may have a webinar on it also in the days to come, कि ये टेक्निकली क्या है, कैसे है। one of us will try to take it, and that is update 7 जून का IBBI का ये नोटिफिकेशन है, हार्डली 3 days ago आया है, तो that is there। और एक इन्होंने निकाला है डिस्कशन पेपर और सिंप्लीफिकेशन ऑफ एनरोलमेंट एंड रजिस्ट्रेशन प्रोसेस फॉर ईज ऑफ एंट्री एंड एग्जिट इन द इंसॉल्वेंसी प्रोफेशनल। अब इन्होंने लिखा तो है ईज ऑफ एंट्री, लेकिन जो मैंने पढ़ा था, अब इसके अंदर वो शायद एक चीज ये ऐड कर रहे हैं कि जो हम ट्रेनिंग लेते हैं, जो 3 महीने की हमारी जो ट्रेनिंग कंपल्सरी है फॉर IBBI एग्जाम, तो उसका भी शायद फ्रॉम हम एजेंसी से लेते हैं, IPA से या ICMA की एजेंसी से या CS की एजेंसी से, शायद उस ट्रेनिंग के बाद भी एक एग्जाम होगा जो हमारे को क्लियर करना पड़ेगा। तो मीनिंग देयर बाय दैट वी मे हैव टू एग्जाम, एक जो नॉर्मल लिमिटेड इंसॉल्वेंसी एग्जाम हम लोग ले रहे हैं, और दूसरा मैंने ये आपको बताया। और एक थॉट प्रोसेस और भी आ रहा था, लेकिन वो थॉट प्रोसेस अभी हुआ नहीं। शायद लिमिटेड इंसॉल्वेंसी एग्जाम को एबॉलिश करने की कोशिश बात हो रही है, सो दैट जो ग्रेजुएट इंसॉल्वेंसी एग्जाम है कुछ उसी के लाइन पे आईपी प्रोफेशन के अंदर एंट्री के लिए कुछ सिस्टम कर जाए। बट यू नो that things never did not come up, but maybe the days to come, but they may come out। तो इस करके that is all। जो हमारे ब्रदर आईपी नहीं बने, जो जिन ब्रदर्स या सिस्टर्स को बनाना चाहते हैं, तो they can have a look on it। Okay, my fifth update is that nowadays social auditor is coming out to be in a big way। इसके लिए मैंने दो साइट्स ढूंढी थी जो मैं आपके साथ शेयर कर रहा हूं, कि विच इज शोइंग की व्हाट द सोशल लीडर्स इन द डेज टू कम विल डू, और यू कैन हैव अ लुक ऑन इट। या जैसा मैंने आपको कहा कि मैंने चैट बॉक्स के अंदर ऑलरेडी अपना ये डाल दिया है, तो एनआईएसएम की साइट है, तो ये सारी आपको डिटेल बता रही है आप क्या कर सकते हैं, कैसे कर सकते हैं। तो यानी कि यू कैन हैव लुक ऑन इट लेटर ऑन। और एक ये वाली साइट थी, ये मेरे को दो साइट्स बड़ी अच्छी लगी। यहाँ पे आपको पूरी इंफॉर्मेशन मिल जाएगी अगर आप एज ए सोशल एडिटर का एग्जाम क्लियर करना चाहते हैं। एज फar as eligibility criteria is concerned, we all professionals are eligible for that, and accordingly I don't think so there will be any hurdle। ओनली थिंग, इसको एग्जाम भी ज्यादा मुश्किल नहीं है। मैंने देखा था, इसका छोटी सी किताब है, एक 40-50 पेज की किताब है, और आजकल क्या कहते हैं, इस पे भी काफी सारी सीरीज मिल जाती हैं, यूट्यूब पे भी काफी सारे क्वेश्चन आंसर्स वगैरह मिल जाते हैं विद सो मेनी पीपल्स। तो इफ एनीबॉडी इज इंटरेस्टेड, so I thought he can take care of it। Okay। My sixth update is that Indian Institute of Corporate Affairs and NALSR launched LLM in Insolvency and Bankruptcy Laws program। अब मेरे को ये बात समझ नहीं आई कि एलएलएम तो वी पीपल आर ऑलरेडी पोस्ट ग्रेजुएट। लास्ट टाइम मैंने अपडेट करा था कि पीएचडी के लिए कुछ ये इंस्टीट्यूट आईबीबीआई ने या आईपीएसीआई ने कुछ कोलैबोरेशन करता, वो बात समझ आ रही थी। इन एनी केस, इफ एनीबॉडी इज इंटरेस्टेड, ही कैन गो देयर। Yes, this is a very big opportunity which I would like to share with you। Institute of Chartered Accountant of India along with इसकी एक कमेटी है जो आईबीसी लॉ देखती है, उस कमेटी का मैं पार्ट हूँ। तो ये जो है, एक फर्स्ट टाइम इन द हिस्ट्री ऑफ आवर कंट्री इज होल्डिंग अ टूर इन सिंगापुर। बेसिकली ये कॉन्फ्रेंस है, एक फिजिकल कॉन्फ्रेंस है 2 दिन की, जो सिंगापुर के अंदर होल्ड करी जा रही है। तो ये मैं इसका जो आई जस्ट टेक यू टू दिस पर्टिकुलर स्लाइड। ये लास्ट वीक ही इसका हम लोगों ने इनॉग्रेशन करा था। तो ये एक टूर है जिसके अंदर आई वुड लाइक कि इट इज टर्म्ड एट रिजॉल्व 2023। 4-5 अगस्त को ये प्रोग्राम है, एंड इट विल बी इन द ग्रैंड कैपिथलॉन, और whereby we will have around 15 plus technical sessions, 25 plus eminent international speakers, and we expect 500 delegates across the globe। It will give you a very good opportunity of meeting with each other and expanding your contacts also। तो ये एक अपॉर्चुनिटी कमिंग आउट टू बी देयर। इसकी अराउंड 500 जो फीस, पार्टिसिपेशन फीस है, वो है अराउंड 500, नॉट अराउंड, एग्जैक्टली 500 रुपीज सिंगापुर डॉलर, विच अराउंड 30,000 रुपीज कमर्स टू बी इन इंडियन रुपीज। And as far as package of staying there and hotel part staying there is concerned, that will institute is also coming out with 3 or 4 type of categories, like the way it was done in the VOCA, which recently held in Geo Center Mumbai। तो wait for the things। इसका एक इंस्टीट्यूट ने हमारे लिए वो ट्रेजर बनाया था, so I would like you to share that also, because that will give you the glimpse of what we are doing it। If I can run it, so let me, I would like everybody to see to it, and then they will definitely be get excited to plan their tour on IBC at Singapore. Let me see if I can run it, please.
वीडियो वाली विंडो शेयर करनी
क्या
वीडियो वाली विंडो शेयर करनी पड़ेगी दिखाने
yeah, I think there was some mistake in it. My office is telling me that although video was playing on my computer, but it was not visible to you. So I have already shared with you this thing there, my on chat box. From there, you can see the video therein later on also. I'm just keeping it. Now let's move to my point number 8. I thought that since it was coming on my computer, I thought कि you are seeing it, but actually you are not seeing it. तो आप इसको जो मैंने आपके साथ शेयर करा है चैट बॉक्स के अंदर, उससे आप देख लेना, उसके लिंक से आप देख लेना. PAN and Aadhaar card linking is very important, not only as an IP but as a CA and other professionals also. That is why I thought of sharing with you. इसकी extended date 30/6/2013 है. उसके बाद काफी heavy fees pay करनी पड़ेगी करने के लिए, तो please take care of it. एक आईपीएस के लिए एक सर्वे आया है, क्या कहते हैं, जो आई जस्ट शेयर इट विद यू. I wish that everybody should contribute to it and help a profession to grow, because इसी तरह के सर्वे के बेस पे बहुत सारे डिसीजंस, पॉलिसी डिसीजंस आने वाले टाइम पे लिए जाते हैं. तो everybody should fill it up and send to the concerned authority, which will automatically go there. Another thing I found is that, for which I would like my IP brothers to have a caution, is that कि एक तो MCA is imposing heavy penalties for non-appointment of CS, जहाँ वुमेन डायरेक्टर इंपॉर्टेंट है उसके लिए बहुत लगा रहे हैं, नॉन डिस्ट्रीब्यूशन ऑफ एनुअल रिपोर्ट्स एंड नॉन अटैचिंग ऑफ सम डॉक्यूमेंट्स इन द MGT 7 and AOC 4 also. So be cautious as far as all these things are coming out in the coming in the coming session also. और अगर आपने पहले भी कोई डिफॉल्ट करा हुआ है, before MCA get hold of you, try to file revised return therein. एक ये बड़ा अच्छा मेरे को आर्टिकल मिला था विच आई एम शेयरिंग विद यू. तो इसके लिंक पे मैं नहीं जा रहा बिकॉज ऑलरेडी 5-7 मिनट ऊपर हो गए. माय शेड्यूल टाइम वाज ओनली अप टू 3. तो आई हैव सेंट द लिंक, यू कैन शेयर इट विद यू. Similarly, if you are interested in more NCLT, NC, LAT and DC cases, तो EVM करके न्यूज़लेटर आता है, उसका मैंने सॉफ्ट लिंक आपको दे दिया है. You can go through there. My 14th point is that 30 जून लास्ट डेट है CP आवर्स की अनस्ट्रक्चर्ड बेसिस CS के लिए फॉर्म भरने की. तो ये जरा प्लीज कंसर्न साइट पे जाके आप you do it. एक बड़ी हैवी नेफ्रा ने पेनल्टी इम्पोज करी है of 1 crore rupees on a firm and 5 lakh rupees on each partner. So, what I mean to say is that NEFRA is becoming very active now. अब बैलेंस शीट्स का सीजन स्टार्ट हो गया है, इधर एज एन आईपी और अदर एज अ प्रोफेशनल आल्सो. तो वी शुड बी वेरी कॉशियस. दीज आर माय 16 स्लाइड के अंदर मैंने कुछ इंटरनेशनल यूज लिए हैं, whereby UK based connected car Tata company, which is one of the largest company, has gone to the bankruptcy. My सेकेंड इज इरिश कोर्ट ऑर्डर्स वाइंडिंग अप फॉर 2 रशियन स्टेट ओन्ड लेजर्स, जो काफी बड़ी कंपनी थी उनके लिए करें। जेनेसिस भी इंसॉल्वेंसी के अंदर चली गई है। और यूरोपियन बॉडी ने भी कुछ डिसीजन लिया है क्रेडिट सुसे के अंदर, विच इज आल्सो एन ग्लोबल कंपनी। स्कॉटिश पार्लियामेंट कमेटी सीक्स व्यूज ऑन ईच स्कॉटिश बैंक्रप्सी लॉ आल्सो। इसकी क्या डिटेल्स है, ये सॉफ्ट लिंक में अवेलेबल है। सिंस बिकॉज ऑफ लैक ऑफ टाइम आई एम जस्ट नॉट ओपनिंग दोज सॉफ्ट लिंक देयर, व्हिच यू कैन ओपन। कोऑपरेटेड इन्वेस्टिगेशन दिल्ली हाई कोर्ट ग्रांट्स बेल टू मैन इन पीएमएलए। ये पीएमएलए का केस था। तो सिंस आर रिस्पेक्टेड सीबीजी इज देयर, तो ही मस्ट बी इन्वॉल्व विद इट। ये क्या पर्टिकुलर केस था आशीष ग्रोवर का, कैसे था? तो आई एम जस्ट पासिंग माय बैटन फॉर दैट टू हिम। और एक केस लॉ और बड़ा इंपॉर्टेंट है कि वेयर बाय एनसीएलटी बेंच हैज हिमसेल्फ ऑर्डर्ड अपॉइंटमेंट ऑफ फॉरेंसिक एडिटर ऑन द एसेट्स ऑफ द कॉर्पोरेट डेटर इन द केस ऑफ सो एंड सो, वेयर आवर स्पीकर निपन जैन जी वाज एन एडवोकेट। तो ये दो बैटन थे जो आई थॉट कि एट द एंड ऑफ माय प्रेजेंटेशन आई शैल शेयर विद निपुन जी एंड ही विल एनलाइटन अस ऑन दिस थिंग। निपुन जी, थैंक यू वेरी मच। मैंने 10-15 मिनट थोड़े से एक्स्ट्रा ले लिए, but things do move in this way. Now I hand over to Nipun ji for his presentation on PMLA.
Thank you very much, Manoj ji, and thank you very much, Amit ji, for a wonderful introduction. I don't think I deserve that. And Manoj ji mentioned about one case, and it's very interesting case, sir, that you just reported, and it's a very good case as far as RPs are concerned, because I was having many queries from RPs that, sir, if the COC is not cooperating or not giving consent for appointment of forensic auditor, do we have the right to do it? And if it is not done, can there be any penal consequences? So we relied on one of the judge orders of IBBI, of disciplinary committee, wherein it was held that forensic auditor appointment has to be done by the RP. It is his duty. Whereas the fee part is something which can be put up before COC, and if COC doesn't pay, then appropriate direction from author NCLT can be taken. So that was an interesting judgment, and I don't think so there is any appeal filed against the order. So I think it becomes a good order for all of us to appoint forensic auditors in the specified time.
तो निपुण जी, ये आपकी जो लर्निंग है, ये इन द केस ऑफ वैल्यूअर्स आल्सो एंड फॉर अदर प्रोफेशनल वर्क्स आल्सो भी शिफ्ट की जा सकती है, वेयर बाय वैल्यूअर तो खैर एक मैंडेटरी अपॉइंटमेंट है, वेयर एवर आईआरपी आरपी फील्स टू अपॉइंट सच पर्संस।
Correct, sir. I think this corollary can be drawn for any professionals which needs to be appointed by the RP. And if he doesn't do so, then obviously because disciplinary actions are being taken. So now I think it is very much important that we make the appointment. And if there is any issue with regard to fee, at least we can go to court and get a direction. So we are not caught in this soup that we have not done anything. It is always better. And I have been advising. And in fact, sir, valuer case also, in one of my case which I had appeared for RP, there also valuer's payment was not given by COC, but when court directed, it was given. The name of the CD is Technoma Plastic Industries. It's NCLT Ahmedabad order. So similar orders have been there, but this is the first order of forensic auditor. And interestingly, in this case, I was for one of the financial creditor who moved because he was into minority. It was Edelweiss ARC, which was into minority. And I think they had less than, I think 28% or something was the stake. But even then court permitted. And we also undertook that we will make the payment because the amount is so huge. I think some 80 crores or something amount was involved. So we said that even we are ready to pay the forensic auditor from our pocket, one COC member, but it has to be appointed. So court even allowed it and said that payment can be done by you. And we are very much sure that when the forensic audit will come, many of the creditors who are actually related party or there is some siphoning, that everything will come on surface.
Yani ki you mean to say that other creditors were not giving consent, since you are only 35% holding, balance 65% was not giving consent because of their indirect involvement with that particular aspect, or some other reason was there? Because
Yes,
it's something very fraudulent.
Very fraudulent. And I think I will share with you some details. Like previously, the stake was, the admitted claim by one of the previous RP was around 32 or 33%. It was reduced to some 28%. Some more creditors were added. And in this case only, previous RP, when Mr. Sanjay Singh was also debarred by IBBI. This new RP came, he got some creditors on board according to whatever claim documents might have been there. So we did not say anything that it is wrong or right. We only said that it appears some of the parties are related party and therefore they should be removed. But because those parties only made the majority of the voting rights, those parties objected. And therefore, we took it to court and court said, no, nothing doing, forensic audit has to be there.
Thank you. Thank you.
So, sir, coming back to our topic today, and it's a very interesting topic, and I think I have been speaking on this topic for quite some forums. And why this is so important today, because everybody is interpreting it in a different manner, which I don't think so is correct. Manoj, is my PPT visible?
Absolutely visible. Please carry on.
Okay. So what I've tried to cover is, and as Manoj ji has guided and our committee has guided, that we should touch upon what is the aspect of two notifications, the 3rd May notification and the 9th May notification, wherein professionals, I am using the word professionals because it not only applies to chartered accountant, but also to company secretary, cost accountant, and also advocates. And when I went deeper into the notification and tried to analyze what is it they are actually aiming at, I was not able to find the objective. In fact, I would also share that I have filed an RTA also with the Ministry of Finance, and they replied to me that this information cannot be given to you because it is confidential information, which if revealed will cause a danger to the confidentiality, integrity of the nation. I don't know what is that reply. Probably I am going to appeal against that RTA reply also, but I think less than 3 days they took it to reply to my RTA, in fact reject my RTA application. So I had asked in that RTA application what was the reason of this notification. So is there any committee, is there any discussion, any file notings which can be shared with us, and whether an institute of all these professional entities were even consulted while giving this notification. So all those queries which generally are there amongst our professionals, I had put it in the RTI. And this is the way we can actually understand why this law came, because that is the basic external aid of interpretation, why a particular notification comes. But till date, I am not able to get any answers as far as the executive or the legislature is concerned. So I have tried a little bit on my aspect, why this notification has come, what is the reason for such notification, and whether it cast any duty or it cast any aspersion on the professionals. So that is very important to understand what is the obligation because of this notification. So here I am limiting my discussion and deliberation on the impact of the notification, because if we discuss PMLA, it's a very big law. It may not be wrapped up in an hour, but I will try to justify whatever obligation of reporting entity that may arise, because detailed guidelines have still not come. So whatever guidelines are there as on date, for other reporting entities, we will try to discuss that, deliberate upon that, and what all could be the penal prosecutions on the professionals if they do not comply with the reporting entity requirements. So one is obviously the parent law. So the PMLA Act, we will discuss some of the provisions which are important. Then under this act itself, just like we have IBC, then we have rules, then we have regulation. Similarly, here there are maintenance of record rules 2005. In this record rules, they justify what is to be maintained, how it is to be maintained, and what is the standard operating procedure which we should follow if we are a reporting entity. What is reporting entity? We will come on to that. But as of now, understand that we are covered under reporting entity. I was trying to find out answers whether the transactions for which they have casted a duty on us, is there any solution? So I have been able to get some answers from Institute of Chartered Accountants Code of Ethics, which is now very extensive, and they have been adopting the IFAC Code of Ethics. So IFAC is the international body, and normally, just like we have in IBC also, we have that UN model, and we try to replicate and bring changes according to Indian scenario. Similarly, in Code of Ethics, CA Institute has also done this. However, I could not find similar provisions for company secretary, cost accountants, or advocates. So I have not been able to find any guidance for other professionals. But for Chartered Accountant Institute, I must say that they have come out with a detailed code of ethics much before what this PMLA rules have come in. Then I would also touch upon that already when we are discharging some of our duty, we are required to take into considerations the laws applicable. So the previous view was that suppose I am advising my client on some transaction and I am not aware what he is going to do, that particular limit has been now increased. Now the law wants us to know more than what meets the eye. They want us to do due diligence. Then they also want us to do extra due diligence. In PMLA terms, it is called enhanced due diligence. So that is also one concept that we need to know our client. So that KYC is the most important part as far as these rules are concerned. Normally, now when we are incorporating company or firm or LLP, there is a declaration which can be given by any of the profession, any of the 4 professional categories. So they have excluded that. I will come on to the notification. But when we are forming a company, we are assisting in the transaction. And therefore, and probably this is a spillover of those Chinese companies. So I've been handling 2 of the cases where there was a FIR made by the registrar of company against the professional. And what was happening? And let me tell you very frankly from my experience, that some professionals were giving their office space to be shown as a registered office for the foreign company. In fact, when a company has to be incorporated, if you want to make foreign nationals as director at the time of incorporation, it is difficult because the KYC you have to do in an enhanced way. So what was generally done was a company was incorporated, local directors were taken. That means local means Indian nationals were taken. Thereafter, additional directors were taken, foreign nationals, and then they were regularized. So that was an easy way to cut short the KYC. So that has in some way now stopped because of this enhanced due diligence which they are expecting from us. KYC related all the procedures, like in fact, for now, you have to verify there, you have to make a video, there is a registered office, there is a director. So there you have to make some live videos to confirm that there is a person like this. That all concept is part of this maintenance of record rules. So that enhanced guidelines are there on due diligence and how to identify a client, do a risk assessment. And if you are suspecting that this transaction might involve money laundering, then don't allow it. That is what this particular requirement says. Now, if we think of what this reporting entity is today, so today it is for, let's say, banks, it is for NBFCs, it is for jewelers, all those specified entities, and we will come on to those specified entities. These all transactions can be curbed. But I don't see a situation where a client comes to us and we suspect there is a money laundering and we take our hands off and say, we will not allow you to do this transaction. Because we are nobody to allow or disallow a transaction, but we will not be enablers. And that is the language used in the international document which we will discuss, because of which these all things are coming. Professional enablers. And when I read that document, it also included advocates and notaries. But interestingly, when we will read the notification, it only includes professionals. It doesn't say specifically for lawyers. So we will discuss the notification now. And as of now, today, the law says that whatever guidelines would come, it would be in consultation with Reserve Bank of India. However, for some of the other entities, they have also notified different authorities, like for precious stone or jewelry, or in short, I will say jewelers. So they have given that to Director General of this indirect taxes. So sometimes they are also giving to regulators of that particular industry. So those guidelines would always come in consultation with the regulator. Because previously here only banks and NBFCs or intermediaries were involved. So RBI was the nodal authority. But with the passage of time, other regulators have been added. Now, one important aspect, and normally we do it as professionals, we always maintain records. And there is a timeline for how much time we will maintain the records. So as far as this PMLA law is concerned, we have to maintain records for 5 years. Now there are two parts to it. 5 years from which date? So if I am having a transaction done where I am involved as per the notification, then I will have to keep the records to reconstruct that transaction, whatever possible documents are there, for the period of 5 years from the date of transaction. Another way of discussing or another way of saying this is, if suppose my relationship with the client ends, let's say in year X, then X plus 5 years would be my timeline to maintain the record. So records have to be maintained in two categories, I would say. One is from the date of transaction, and one is from the date where the client is ceasing to exist as your client. So this is broadly what PMLA says. Now we already have other regulations which requires us to maintain records, and we have been doing it, like Companies Act, Income Tax Act, Auditing Standard, all those have some specified timeline. So I don't think this is going to be cumbersome. But what is going to be cumbersome is that PMLA guidelines would come out or would spell how these particular records have to be maintained in a particular format. Like we are maintaining audit working paper, or we are maintaining records like in income tax, so that income can be again recalculated, recorroborated, all those ways. I think PMLA will come out with a specified guideline how it has to be reconstructed. But as of now, the Act says all the documents have to be maintained in such a fashion that the transaction can be reconstructed. That is very important. Reconstruction of transaction should be possible. So they have given us a subjective guideline that yes, you should be able to reconstruct it. And why this particular PMLA is now modified, or why professionals like us have been included. Whenever we are signatory or a party to an international treaty or an agreement, we are required to make a law in our own country. And all the laws which we are studying, maybe IBC laws, we are saying, Income Tax Act, we are saying, black money law is there. Now, PMLA is also the same thing. And there is an international task force, FATF, Financial Action Task Force, of which India is a member, not a permanent member, but it is a member. And every year there is a review, and they ask other people to maintain so and so amendment. And this is also a very important network, because we come to know, if suppose there is a terrorist funding, we will come to know which all countries are sanctioned. Sanctioned means banned. There will be no transaction through those countries. So that Financial Action Task Force actually gives us an indication to which countries we should work, what is the due diligence we have to exercise, and what all steps as a country we have to take. Now, this FATF review is pending, I think, in this year, November, and therefore this notification has come. That is what is expected from us, that we come out with an appropriate amendment in the law to bring into ambit the professional enablers. And I will come to the exact wordings used for the professional enablers in few slides after this. But yes, that is the reason why these two notifications has come. Now, in Indian context, and we all are aware, ED, we have been now seeing day in and day out, the Enforcement Directorate is there. Enforcement Directorate are considered to be, I would say, a very strict regulator, a strict investigative agency. And it is very important to understand why this Enforcement Directorate is now coming in almost every case. Whether it's a political case or an income tax case or some other case, this Enforcement Directorate is coming. Now, Enforcement Directorate is actually having power under 4 laws, and one of them is PMLA. So FEMA is also there. This Fugitive Act is also there. Coffee POSA is also there. In all these acts, Enforcement Directorate is the authorized person to do investigation, to do inspection, to do search and seizure. Whatever powers under this law are there as given to Enforcement Directorate. So ED is basically a department which has all these powers. Now, what Enforcement Directorate will work upon? So they will work upon some data which is coming to them, some information which is coming to them. So what they are doing is, they are giving guidelines, rules, and they're coming out with circulars to ask the reporting entities to report them a particular transaction. Now, transaction could be justified in the terms of money. So let's say they have prescribed an amount of 10 lakh rupees. So if more than 10 lakh, there is XYZ transaction, you have to report. Reporting entity has to report. Let's say there is a real estate agent. Now he has done a turnover or a transaction of 50 lakh rupees or more. He has to report. If there is a jeweler and there is a turnover of more than 2 crore, jeweler, I would explain, precious stone, dealing in precious stone, those are also prescribed. So more than 2 crore turnover, they are also covered. So sometimes they fix it by value. Sometimes they fix it by transaction. So if you are doing, let's say, if you are entering into a transaction of virtual digital asset, Bitcoins, cryptocurrency, all this is also included. So that has to be reported by the reporting entity. So in case of that, the exchanges which are dealing in virtual digital asset, they have to report. So depending upon the transaction, depending upon the industry, they are coming out with notifications saying that you have to report XYZ transaction. You have to report ABC transaction. So every industry and every person included in the reporting entity is required to report enforcement directorate. Now, enforcement directorate does not gather the data directly. They have a wing called Financial Intelligence Unit, FIU. And we have to, as a reporting entity, go on that website and register and give all our relevant transaction. So whenever those transactions are punched in, that transaction does not mean it's a money laundering transaction. We have to be very clear about it. It is only a transaction happening between X and Y, which is defined under the notification. Whether it will be falling under the laundering or not, that has to be checked by the authorities. We only have to be susceptible, or we have to apply professional skepticism to the extent what is given in the rules. We have to only do it. Let's say I am incorporating a company, and let's say XYZ nationals are involved. And that particular reporting of the formation of that company has to be done to Financial Intelligence Unit. Suppose I am a real estate agent and I am doing a transaction of, let's say, 50 crores. I have to report it to Financial Intelligence Unit. That does not mean I am involved in money laundering. I am only reporting the transaction. And just by reporting, there is no offense. Offense will come if that and this transaction, which probably is asked by the FIU, they will apply some type of parameters. They might connect to some offense. And if that offense at that transaction gets matching, then there is an offense under PMLA. So basic thing has to be, if the transaction has involvement of some proceeds, which are ultimately of a crime. So the words used are proceeds of crime. If that proceeds is of coming out of some offense which is defined, I will come on to what all offenses are defined, but those proceeds of crime will ultimately make the transaction a transaction falling under the category of money laundering. Now they collect all these data, and normally, and this I think I'll just show you how it. So these all authorities are there which we are going to use our data. So whatever we are going to provide to the Financial Intelligence Unit, it will be all shared with these all authorities. So if suppose our data is going to FIU, it may go to CBI, it may go to income tax, it may go to CBDT. We don't know. All these agencies are working with FIU. They have a direct dissemination of data from these FIUs, and they are protected. Means confidentiality rule does not apply. It will be shared to all these authorities. Now, one question, and probably which have been asked by more than few professionals to me, that sir, if suppose there is money laundering, does it mean that suppose I have some, everybody may have some cash income. Does it mean that we are doing money laundering? Answer is no. It is not money laundering. I may have done suppose some unaccounted transaction, or may have not disclosed it to, let's say, income tax department. It is possible. Now, whether I am doing money laundering? So the answer is, there is a white money, which we all have, tax money, accounted money. There could be some money, which is black money. And black money, I mean, that money which we have earned through legal means, but we have not paid taxes, let's say. We have not disclosed it to the tax authorities. It is possible. Now, this money, if suppose income tax department comes to know about this, what can be done? I can pay the tax, I can pay the penalty, and that money from black becomes white. So black money is different. Though there is an offense under income tax law that you have not disclosed that money, and therefore there would be a penalty also. But that does not mean it's a crime as far as PMLA is concerned. It may be a crime or an offense under Income Tax Act, but it may not be an offense under PMLA. But what does PMLA? And I am talking about the basics. You will not find these words in the PMLA Act. I am talking about the basic structure. This is basically red money, or I would say blood money. What is this kind of money? So suppose somebody is doing a terrorist activity. He is getting this money. Somebody, let's say, has given a threat and got some ransom money. Somebody has done some smuggling and got this money. Smuggling of some goods which are prohibited under law. It could be Customs Act. It could be Forest, this Wildlife Protection Act. So anything which is an offense, and I will come on to all the category of offense, but approximately there are some 25 categories of offenses. Under that law, if there is an offense, then it is a crime, and then money earned from that crime is proceeds of crime. And then it becomes an offense of money laundering. And this is very, very important to distinguish between black money and red money or blood money. Normally, it is called blood money. So untainted money and tainted money. So this is the category that when there is a tainted money, so this is blood money is referred to as tainted money. If somebody has tainted money or has created assets from tainted money, then that particular asset is liable for confiscation by Enforcement Directorate under PMLA law. And ultimately that asset goes to the government. So I would say long and short of this particular law is if somebody has made an assets out of proceeds of crime, ultimately that asset will go to the government and that particular person would be liable for offense prosecution. Now coming to our notification. So there are two notifications which we are going to discuss. And the first definition which I am going to read is the reporting entity. So now, you see, reporting entity till now, if you barely read the law, it has banking company, it has financial institution, and it has intermediary. These three were the only reporting entity. And rightly so, because normally the money is transacted through these entity. Like if you go and withdraw, let's say 11 lakhs for cash from the bank, what bank ask you? Bank will ask you to give a purpose letter. Why are you withdrawing so much cash? They will also put it in the reporting under PMLA. They have that KYC AML guidelines. You can read it. It is available on the RBI website. So these three we understand. Directly money is involved. The last limb is designated business or profession. So they say a person would require to report or a person would be covered under reporting entity if he is doing a particular business or he is doing a particular profession. Now, what is this particular business or profession? So I'm further going on to what is the definition of person having a particular business or a profession. So first one is that if somebody is into the gaming activity, playing of chance or maybe casino or all these activities, so that person becomes designated business. So if I am doing a casino activity, I will have to report all the transaction to FIU. Suppose I am a registrar under Registration Act, I am required to report. If I am a real estate agent, I will have to report. I've already told you these are the categories, but the limits and the threshold of the transactions I have told you separately. So like real estate agent, it is 50 lakh rupees is the threshold. So above 50 lakhs, he has to report. A dealer in precious metal, precious stone and other high value goods, as notified, it has been notified 2 crores or above in the turnover, the financial turnover in the previous year. So what they do is they categorize a person that this particular industry and person doing this business is covered. Then they give further guidelines by way of notification. This is the limit. Dealer in precious metals or stones. So normally I've already told you the jewelers are all included. If they are dealing in XYZ metals, XYZ stones, those are defined like sapphire, emerald, they all are included. Then the person engaged in safekeeping and administration of cash and liquid security. So again, somebody dealing with securities. Last one is important for us, and here comes the notification with respect to this. Last clause says, person carrying on such activity as central government may by notification so designate from time to time. Now here under this clause, they have come out with this notification of 3rd May. Now this 3rd May notification, what it says, and I am reading it from beginning because the opening part is very important. It says, financial transaction carried out by a relevant person on behalf of his client. So there are 3 things: financial transaction, relevant person, and carried on behalf of his client. So first of all, there has to be a transaction which is of financial nature. Now, if you say what is the meaning of financial transaction, it is not defined under PMLA law. Transaction word is defined. I'll come on to transaction word, but if we go by normal parlance, financial means if money is involved. So if there is a transaction of money involved or a financial transaction carried out by a relevant person. Now, this is very important. Who is relevant person? So I'm skipping the right part. Let us come on to the next slide. Relevant person is a practicing chartered accountant, a practicing company secretary, and a practicing cost accountant. All these 3 people are relevant persons. All 3 practicing professionals. So mind it, the words used are practicing professional. They are referred to relevant section of relevant law, which says practicing professional. Coming back, financial transaction carried out by relevant person, that means practicing professional, CACS, CWA, on behalf of his client. If these professionals on behalf of their client do these activities during the course of his profession. So as a professional person, if I am discharging a transaction on behalf of my client, then I am covered under this notification. Now you see what all are covered. So they have covered 4 types of transaction. So one is buying and selling of immovable property. I will come on to the aspect whether these transactions should be done or not a little later. But let us first understand what this notification is trying to cover. So it is saying if we are buying and selling any immovable property on behalf of our client in discharge of our professional duty, 3 things have to be there. Buying and selling of immovable property on behalf of our client and in discharge of our professional activity. Then they say managing client money, security or other assets, managing bank account, saving account or security account, organizing of contribution for creation, operation or management of company, and similarly for trust or LLP, or buying and selling only any entity. So in abstract sense, it says if we are dealing in all these transactions, then we are covered for the purpose of reporting entity. We are not doing any money laundering. People are misinterpreting this notification. We are only covered for the purpose of reporting entity. Reporting entity means if these transactions are done, we have to report to the Financial Intelligence Unit, FIU, under PMLA law. Now, let us come on to the aspect whether these particular transactions can be done. So, and I think now I would request participants also to give me some comments whether on behalf of any client can we do any purchase or sale of any immovable property? Yes, participants, give me some answers. Is it possible that we buy and sell any immovable property on behalf of our client?
Yes, under POA we can do it.
So you are buying and selling an immovable property on behalf of your client. So basically you are taking the authority to purchase and sell, whether that decision is yours or of client.
Okay. Sometimes it is our decision, sometimes it isn't.
See, if we are holding a power of attorney, if we have done a transaction, then can in the court you can appear as an advocate or a chartered accountant for that person? So this is one question I am keeping it open, and I will
I think
answer.
as a party in person, we can appear before court, but as a chartered accountant, we can.
So there is a difference. I am reiterating the opening part. During the course of profession, if I am party in person, then I am not a practicing professional. Then I am in a separate capacity, in my personal capacity. Whether in course of our profession, are we allowed to do something like this? In my view, no, and I will come on to the relevant provision. Second is, can I manage clients' money security?
Yes.
Can I be the signatory of a bank account in my professional capacity?
Yes, sometimes we do that.
Manoj
No,
sir,
we can't.
Manoj sir, you are on mute.
Sorry, our code doesn't allow us to manage the client's money. I understand.
Correct. Absolutely correct. So managing client money, management of bank account, buying and selling of immovable property, or doing anything with the client's asset. In simple words,
Yeah.
any client asset, we cannot deal with on behalf of our client. We can definitely advise.
निपन जी एक छोटी सी रिक्वेस्ट करता हूँ, जैसे जैसे लंबी डिस्कशन हो जाए ना, तो ये शेयर जो है ना इसको स्टॉप कर दो, so that live discussion will be better.
Yes, sir, I will come on to the relevant code of ethics and then I will stop the sharing.
Yeah.
Yes,
Yes,
please.
please.
Will give us an idea of what all provisions I am talking about. So till this, I am putting a full stop on this particular slide, that these transactions are not permitted except one. I can advise my client for raising finance. So like in IPO, I can obviously give certificates. I can advise him as an advisor to the issue. I can advise him for creation of a company. I can ask him to bring finances from XYZ place. I can also help in taking loans from the bank, but that will not be organization of contribution for creation of a company, even if we take the wider sense. Because under professional capacity, if we are involved, I will not be included. That I will come on to it, how we will not be included. But yes, these transactions, which are 1, 2, 3, we cannot do it. And our code of ethics does not allow to do it. And I will come on to the relevant provision. Let us go on to the 9th May, that things will become very much clear. So now 9th May transaction. See, 9th May notification and 3rd May notification, only 6 days difference. I don't know why these two notifications were not coming on the same date. Whether 3rd May notification left a gray area which 9th May notification tried to cover, whether 9th May notification was well thought of when 3rd May notification came, I don't think so. Because 3rd May notification and 9th May notification hardly has 6 days gap. 3rd May notification talks about profession, 9th May notification talks about business activity. Now I am reading 9th May notification and kindly read with me. It says following activity when carried out in the course of business on behalf of or for another person. So first notification was with regard to professional activity. This notification is with regard to business activity. First notification was with respect to client. Here the words used are on behalf of or for another person. So here everybody is covered, not the client. Professional things are not covered, which we understand from the opening paragraph of 9th May notification. Now it talks about 5 things. It says acting as a formation agent of companies and LLP. I am not aware what is formation agent, but let us apply our mind. So if I am assisting in creating a company, can I assist? Yes. We all file digital signatures. We all help to create companies. We all help to create LLPs. As an advocate also, as a chartered accountant also, company secretary also, and cost accountant also. But then I get confused here. If I go on the heading, it says business activity. I am not doing business. I am doing profession. So whether I would be covered under 9th May notification? Because here the words used are business, Third main notification word used was profession. So when I read this, there is a confusion and everybody is rightly thinking it is unclear. Now, when I go just below the 9th May notification, they have added an explanation. Here, what they say, for removal of doubts, it is clarified. What it is clarified? Now you see the third column, the yellow one. Any activity that is carried out by an advocate, CA, CS, CWA, who is engaged in the formation of company to the extent of filing of declaration under section 7(1) of the Companies Act. So now, if I am making a company and I am giving a declaration, then I am excluded. In my view, I was already excluded because this only covers business activity and not professional activity. But because of this 9th May notification explanation, now I get to understand even the 3rd May notification, which was talking about formation of company, I am getting excluded because of this. So I have to read 3rd May notification and 9th May notification together to understand whether I am falling or not falling under the category of a formation agent. So I am not falling under the definition of formation agent. This is the interpretation of these two notifications. Again, this is my view. We are yet to see any guidance coming from the authorities or our institute or institute of all the 4 professionals, whether we would be included or not and to what extent. Because normally in formation, we would be advising, we would be giving this declaration or digital signature normally, which we annex, at what level they are going to include. But because of 9th May, I can safely say I am not covered under this notification. Because ultimately, these all notifications are below 2(1) SA. And I have already told you what is 2(1) SA, the definition of the reporting entity where they are thinking of including us. Let us get back to 9th May main notification. Now here, second, and this is very important, and I was giving you the example of Chinese company, and one of the case which I had been taking care in the court, acting as or arranging any person to act as director, secretary, or a partner of a firm for a company or an LLP. So suppose, and this was happening, and I must tell you that I have seen the cases like this, where a professional was arranging their relatives for making the company. So at the time of creation, as I told you, local directors are required and their KYC is easy. And then additional, by way of additional director, foreign nationals are introduced and regular directors are getting retired. So that particular way of adding somebody and subtracting somebody, they have now clearly said, this is not a business. If somebody has done this, he or she is covered. Again, as a professional, I will not make any document for making somebody a director or delicting somebody as a director, because it is according to that particular person's will, he would be included or subtracted. So again, as a professional, I will not be included. But if somebody is providing such service, then definitely he or she is covered. Now you may say, sir, suppose I am arranging somebody as a company secretary of the company. It is possible that a person will have to call for suitable candidates. If that company meets the threshold, then a company secretary will have to be appointed. Now, again, I have first told you the explanation with regard to declaration for company formation. Now see the second column, the gray one. Any activity that is carried out by an employee on behalf of his employer in the course of or in relation to his employment. So if there is an employer-employee relationship, again that is excluded. So a company secretary will not be included under the reporting entity definition because they are in employment of the company. Suppose there is a CFO in the company. Again, employer-employee relationship not included. So reporting entity definition, the words used are business activity, but it excludes somebody who is into the employer-employee relationship with regard to the specified transaction. Now I am coming back to the transaction. So I suppose first one is clear, formation. Second one is clear, providing somebody to act as director or secretary. Now third one, if somebody is providing registered office business address, accommodation, correspondence, or administrative office. In short, providing address to the company by whatever name called. For a company or an LLP, if you are providing any address, you are covered. Now there is a very big catch here. I am giving my particular office on rent to somebody. Whether I am covered? Very simple question. I am a landlord, there is a tenant. I am giving my of this premise on rent or maybe on lease to somebody who is a company. So whether I am covered, now let us go again to the exclusion or the explanation. First one, it says any activity carried out as a part of agreement, lease, sublease or tenancy, all this with regard to land or building on any space consideration, if it is subjected to TDS under 194I of Income Tax Act, it is excluded. So now see the irony, and I'm still thinking that they will come out with this clarification. Otherwise, what will happen? So I think Manoj would be better to answer on this. They say that, sir, for 194I, if you are subject to tax deduction under 194I, you are excluded. So I think there is some limit.
2,40,000 की लिमिट होती है 194I की, तो मीनिंग देयर बाय कि अगर मैं 2,40,000 से कम का रेंट पे कर रहा हूं तो क्या कहते हैं इसके अंदर कवर हो जाऊंगा। 2,40,000 से ऊपर पे कर रहा हूं तो कर रहा हूँ। और दूसरी बात यह है कि मैं 2,40,000 से ऊपर पे कर रहा हूं तब भी 194I नहीं कर रहा, तब भी नहीं कवर होगा। और तीसरी बात, अगर सपोज कर लो इस चीज से ओवरराइड करने के लिए मैं 20,000 रुपए का रेंट ले रहा हूं, मैं उसके ऊपर गलती से 10% टैक्स काट दूंगा 194I के अंदर, बिकॉज लॉ डज नॉट स्टॉप मी ऑफ डूइंग इट, उसको अल्टीमेटली क्रेडिट मिल जाएगा। तो मीनिंग देयर बाय कि अगर आपने बचना है तो 194I में उसका TDS काट दो। Sir, this is what I can understand. Please tell me.
Absolutely, sir. Absolutely. You have hit the nail exactly. If I am having less than that amount, the law says I am covered. If I am having more than that prescribed amount, since I have deducted TDS, no need to comply with reporting entity requirement. I think this is an irony. Probably they are focusing on high value transaction and they might come out with a threshold, because otherwise, even if I charge ₹1, I am covered under this notification. But if I am charging, let's say 2,40,000 and more, then I am out. So this cannot be the purpose according to my opinion, and therefore there would be some guidance on this aspect. Now let us go back to the notification. So whatever I had discussed for company and LLP, same thing is with for trust. So more or less the same point, employer-employee relationship excluded. Otherwise, anybody who is providing any type of director or somebody professional on the board or somebody as a trustee will definitely be included under the reporting entity requirement. And last one is a nominee shareholder. So that is not of much importance to us. Then here the exclusion, we have read tenancy, we have read employer-employee relationship, and also professional in the capacity of declaration. So these three are excluded. And last one, intermediary, is excluded from this, but even otherwise they are included. So they have just clarified intermediary is not covered under this clause because they are covered in the main clause. So meaning thereby, 3rd May notification and 9th May notification, both have to be read together. All the transactions which are given in 3rd May are relating to professionals. 9th May notification are related to business, and the activities which are given for professional and business will have to be seen from the perspective of giving reporting to the financial intelligence unit. Now, why this happened, and this is a OECD publication. I would share this particular publication. Manoj will disseminate it. Here, they have specifically talked only about chartered accountants while they were thinking of bringing this. Though if you read the complete report, they use the word professional enablers. And they say it could be any professional, including advocates and notary. However, with respect to India, and this is box 17 of this particular publication, wherein what they say, and I think it is a very misinterpretation which they have done. They say 400 professional enablers list was shared with the CA Institute, And there was a conflict of interest because the institute and the members are of the institute only. So the disciplinary proceeding did not proceed. And therefore, now NEFRA has come, and therefore now more penalties and debarment will happen. So what is the object? They are saying that there were some shell companies. Those shell companies were made because of some professional enablers, and those professional enablers were not penalized or were not prosecuted, and therefore now the legislature has come out with this NEFRA authority. I think, first of all, my view again is this particular, what I am not aware who is representing India in this OECD, but the interpretation done by OECD vis-a-vis India is incorrect. See, what they are saying, to eradicate shell companies, government constituted a special task force. And we all are aware what was happening. Annual returns were not filed for more than 3 years. They simply came out with a notification debarring all the companies, striking off the companies, and disqualifying all the directors. Many of the matters went to different high courts, and mostly all high courts gave stay. Ultimately, the companies which were not doing any revenue were closed in the proper sense and given the penalty, whatever was applicable. Court allowed them to get restored and revived. Those companies in which there was no business, ultimately they were again struck off. The only point was whether the disqualification was correct or not. That also got relief from the court, saying that they did not proceed with giving appropriate notice. So I think somewhere this is a misinterpretation that all the companies were shell companies. Maybe 5%, 10% companies may have been shell companies, but not majority of them were shell companies. And to say that all the shell companies having some professionals had some involvement in money laundering is absolutely wrong statement. And therefore, I think that some relook will have to be taken on this aspect, because it is very, very defamatory when they write like this in an international document. So again, these are my views. Now let us come back to PMLA and why this particular PMLA law is very stringent, very strict, and every now and then, whenever we hear about the Enforcement Directorate, we always say, and in fact, the best of the best, in fact, Justice Nariman, the retired Justice Nariman, also recently I was hearing his speech. He also said that this law has become draconian law and it is not permissible to get a bail easily. Why so? Because of this section 24. And I tell you, it is only a 2-liner section, but a devastating one. Just like we have section 238, only one liner, and IBC overrides all other laws. Similarly, this section 24, it says that burden of proof is reverse. Normally, our Indian jurisprudence is that a person is not supposed to be guilty. He is supposed to be innocent, but he has to be proven guilty by the prosecution, by the state, by the police, by CBI, whatever. But here, the words used are very important. In case of a person is charged with an offense of money laundering, see, charging of an offense has to be with the authority, that is obviously going to be the Directorate of Enforcement. Court shall, the words used is shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. So the person, he has not even got a chance to prove, but it is presumed that he is an offender. So this is very, very draconian. In case of any other person, the authority or court may presume that such proceeds of crime are involved in money laundering. So if that particular person, X person, is charged, he will be put behind the bars without hearing, because there is a presumption that he is involved in the money laundering. But if any person who is maybe assisted the transaction, may not have got anything, in only that case, that person will get a bail. That is what this burden of proof section 24 talks about. It's only 2-liner. But if you read about this section, Ram Jethmalani ji, who then was now late Jethmalani ji, said that this 2-liner section is very draconian because it is against the constitution, where we presume an innocence. Here they are presuming proceeds of crime. See, you can presume whatever you want, but at least that person should be given a chance. But because they are presuming, that the charge is putting that person and owners, he will not get a bail until the investigation is over. And therefore, we are seeing many people who are charged with the sections of PMLA are behind the bar, even when the offense has not been proven after 6 months or 1 year or maybe 3 years. The rate of conviction is very low. We all are aware. But this is the hard reality.
निपुण जी, अब हम इसको आईबीसीसी कॉलोनी से लें तो आईबीसी के अंदर मे को शेल, शेल को मे बहुत बारी करा गया है। तो इस ड्रैकोनियन प्रिजन के अंदर इस चीज को हमारी ऑनरेबल हाई सुप्रीम कोर्ट ने क्यों नहीं इस तरह से इंटरप्रेट करा, जबकि दिस सिचुएशन इज we have seen quite frequently in our IBC, whereby in the plain reading, all timelines prescribed for judiciary is directed in nature, चाहे वहां पे shell लिखा है या double shell लिखा है या triple shell लिखा है. Why, being despite the fact it being a criminal in nature, putting somebody behind is like killing his independence, which no constitution in anywhere in the world allows. Why our Supreme Court, Honorable Supreme Court, has not interpreted till date it as directory in nature instead of treating it as a mandatory?
So, sir, I will just after 2-3 slides, I will also come on to the section 45, wherein there are twin conditions of bail. In fact, that was struck down by Justice Nariman, who then was, and his commentary only when I was reading on this section 24 and his deliberation, he had struck down this section also, read with that section of 45, and he was saying that these are unconstitutional. But then recently, Supreme Court has reversed that verdict obviously by a larger bench in the case of I think Vijay Chaudhary versus Union of India, wherein now they have upheld those conditions and they have confirmed this presumption. So again, sir, until and unless now legislature takes a different view, Supreme Court verdict is final, and that is a very, I would say, a sorry state of affairs. And in fact, we all are aware, and the biggest example is the person who brought this law himself was behind the bar because of this, who was then Finance Minister, Mr. Chidambaram, was kept because of this PMLA only. So somebody who brought the law never thought that it could be misused like this. And these amendments have come, then has been confirmed by the court, by the highest court. So now I don't think so that court will take a different view until it is referred to a bigger, larger constitutional bench. Probably only legislature can now resolve this problem. And I don't think so that they are going to resolve this problem. And why so? I will come on to the schedule of offense, which they have now keep on expanding. And now they have expanded it to such an extent that I tell you, if technically we have to go each and every complaint with the police department also today, PMLA can be invoked. By default, it can be invoked. And that is again my opinion. And I will just show those sections to you.
Sir, legislature क्यों इसको change करेगा? उसके तो benefit के लिए है. Because he is getting so much mileage out of it, maybe from the opposition political alliances, or maybe, whatever be the to settle score, or maybe anything there. अब आप party के लिए, PMLA के अंदर उनको अंदर करके रखा हुआ है. तो सिसोदिया जी को एंड समथिंग लाइक दैट, तो लेजिस्लेचर तो कभी करेगा ही नहीं. ये तो आप जैसे सीनियर एडवोकेट्स और एनलाइटेड एडवोकेट्स हैं जो थोड़ा सा ऑनरेबल सुप्रीम कोर्ट का, जो हाई कोर्ट का दिमाग खाएंगे कि भैया दिस इज किलिंग आवर फंडामेंटल राइट्स. इट्स एब्सोल्युटली किलिंग ऑफ आवर फंडामेंटल राइट्स. क्या मेरे को जेल में डाल दोगे जी बगैर ये प्रिज्यूम करके कि मैं एम गिल्टी, चाहे वो 6 महीने, साल, 2 साल तक प्रूव ना हो. So this is a very, in my personal opinion, a sort of sorry state of affairs as far as our legislation is concerned.
Absolutely, sir. And again, though it will become a political debate, but yes, if there is a change of probably the government, they might come out with these amendments because they have been highest vocal. Mostly, as you rightly said, many of the parties in the opposition, they have been condemning this. And in fact, when it was struck down and then it was upheld again, a review petition was filed. But as of now, that review petition got rejected. So I think so that this is going to be as it is, at least for some years, until we see some change in the state. Because this presumption, sir, I just tried to connect it with some other laws. And I was discussing it with one of my criminal lawyer friend. He said me, Nipun, these particular laws are just like POSCO law. There is a presumption. Always there is a presumption that something wrong has happened. the other side has to defend. So the object of the law itself was to put somebody behind bars because he was involved in some heinous activity. The law's objective was that. But now, after modification and modification, sir, I will just come on to the schedule offense. It says even the offense under Companies Act, section 447, is punishable under PMLA. So by default,
एक थोड़ा सा और गाइड कर दीजिए. Do any other country also have same practice which we are seeing in PMLA in our country?
Yes, sir. As I told you, that OECD report, if we read, they talk about sir professional enablers. So in that professional enablers, they have said that everybody who is involved in the money laundering transaction, everybody is included and reporting entity requirements are there. Problem in India is now, because the law is so stringent, what will happen? And I'm just coming on to those sections, that once suppose you have done a transaction, you have been advising a transaction, you are not aware that ki ye proceeds of crime hai. But because somebody else is caught, you are also part of the suit. And I will not take the name, and there was a recent order. One of the big law firms defended somebody who was obviously arrested by Enforcement Directorate and successfully defended. They got the fee from the person. Now that lawyer's firm bank account was attached, saying that the money which they have got is a part of a proceed of crime of that person who got the bail. Ultimately, that person again was arrested in another particular transaction, but from one transaction where they got him scot-free from the court, they got the money, the complete bank account was freezed. They had to go to court, deposit bank guarantee to the amount which came from that particular person or the alleged criminal, so-called, and then they only got their account free. So now even what is happening, if we are a professional, and I'm talking about for lawyers, I'm talking about chartered accountants, when we are working for some clients and that client gets caught in some particular transaction, even that particular fee which we have got from that client, we will have to maybe sacrifice it.
सर इसमें एक थोड़ी सी बात ऐड कर दूं. दिल्ली बेस्ड ये एडवोकेट फर्म थी, तो उन्होंने जो फीस ली थी ना, वो द क्वांटम ऑफ फीस व्हिच दे चार्ज फॉर पर्टिकुलर ट्रांजैक्शन, वो किसी भी तरह से प्रोफेशनल एडवाइस या प्रोफेशनल काम करने के कंसोनेंट नहीं थी. वो जिसको हम कहते हैं ना सेटिंग वाला सिस्टम, ये कुछ उस तरह की फीस थी. दैट इज व्हाई ईडी वाज क्वाइट हैवी ऑन इट. सॉरी, आई एम इंटरप्रेटिंग. आई एम रियली सॉरी फॉर दैट.
So, sir, probably I was not referring to that case. I was referring to a case of Bombay.
Okay.
Probably you are referring to Delhi case, but I was referring to Bombay case, and this has happened, and I am aware about that transaction. In fact, that judgment also I will probably share with you, and I think that was Amarchand Mangaldas was the law firm.
Please carry on.
Yes. So now let us move ahead. What can be the worst possibility? So when we talk about worst possibility, we will have to refer to what can be, whether it could be prosecution, going to jail, or only a fine or a penalty. So when we are talking with respect to powers of the director, so when I am saying director, it means enforcement director. What can they do on reporting entity? So our case today is only of reporting entity. Suppose I do not report, ignoringly, not knowingly, what can be done? They can issue a warning to us. They can issue a specific direction. Suppose for this client, you give us all the documents which you have. They can also ask us, you give us reporting with respect to ABC company on a weekly basis, on a fortnightly basis, or on a monthly basis. These all three things they can do. And at the best, they can impose a fine of 10,000 rupees minimum, or could exceed to 1 lakh rupees for each failure. Now you see the words used are each failure. So if there are 5 failures, it could be 5 lakh. 10 failures, it could be 10 lakh. So suppose there are number of transactions which I have to report. The penalty, how they are imposing is on per transaction. It is counted as per failure. I have also added some case laws in which penalties were imposed on the reporting entities that I will share, that will clarify how they are calculating the penalties. But this is the worst possible thing which can happen to a reporting entity who fails to report, because it is only a failure to give reporting. So there is no prosecution. So I think this should be a sigh of relief to all the participants that nothing wrong we are done. At the best, it could be a monetary penalty. Now, what all powers are there with obviously the director or the ED? So they have all these powers, and probably more or less we are also aware how these powers are used. They can issue summons, they can ask you to examine a note, file affidavit, give them books of accounts, anything they can ask, just like as a civil court, they have right to ask all these documents or things from us. Now, when I was reading the law, and interestingly, Section 54 already casted the duty, in fact, in the Act itself, on the professional members of CA Institute, CS Institute, and Cost Accounting Institute, that they are required to respond to and assist in the inquiry, anything from the Enforcement Directorate side. So even otherwise, when this notification was not there, whenever there used to be a summon or a notice to give information, call for books of account, we were already cooperating. And if we could not cooperate, they had all the powers. Section 54 casted as an obligation. Now, if you ask me, sir, whether advocates are covered in this Section 54, answer is no. They are not covered. Only these three professionals are covered. Yes, other professionals are also covered, like SEBI or Forward Market Commission, or all those other government bodies are also covered. But as far as we are concerned, we are covered. Now, what can happen if somebody is being called and he refuses to answer any question put to them? Or during the course of statement, they might ask you to sign something, and it happens. And this is again my personal experience. It happens. They call professionals or somebody who is in that particular transaction to sign something, or they will ask you something and you don't know the answer, or you say, I don't want to answer. So refusing to answer, refusing to sign, or may not be appearing on, maybe someone is given and that person doesn't appear, or books of accounts are asked to be produced and not produced. What worst can happen? There could be a fine from 500 to 10,000. Again, the words used are each failure. So suppose an ED is sending you 50 questions and you are not replying to 50 questions. What could be the worst scenario? 50 into 10,000. That could be the worst scenario. Now, suppose I am having an enemy and I want that, let us complain against this enemy to Enforcement Directorate. Let there be a search seizure carried out on his property. So I am doing it something knowingly that he is not a money launderer, but still I am making some false complaint or false allegations, and cause what it is causing, it might cause an arrest or a search at the premises. Now, in this particular case, there is a provision of imprisonment. So Section 63 has two parts. One part is maliciously or wrongfully telling ED or misleading ED to do some arrest or search. Then, sorry, that person who is making such false information to ED will also be prosecuted. But suppose I am only called for under some summon, I am only called for some maybe to give statement or to reply, and I do not comply, then there could be a fine imposed. So this is very important, Section 63. So I've told you both the Section 13 and 63, these are only relevant to us when we are a reporting entity. At the best, we could get some summon and we will have to go and reply there. Now, sir, whether there is an offense which I come to know, there is no notification, forget about notification. If some offense I have come to know, whether I am required to tell that authority. So if somebody comes to know of any of these offenses, there is a provision under CRPC that the public is required to give information to if these offenses are attracted. So it is like a whistleblower. If I have come to know of a crime, I will have to go and report that particular crime to the authority. Now see, this was already there, this is already there. There is no correlation with PMLA. But in general also, if we are aware that there is some terrorist funding, there is some money laundering, there is some wrong thing happening, which is according to us illegal, we even have to go and report it to the authorities. Now let us come on what Institute of Chartered Accountant has issued, and very interestingly, and this I always ask, and I think Manoj ji and all other participants, most of you are also chartered accountants. So as far as our Chartered Accountant Institute is concerned, we have adopted IFAC Code of Ethics, more or less modified according to Indian scenario. So I think when I cleared, I think almost 15 years back, I also read Code of Ethics, which was very thin. Now we have 3 volumes of Code of Ethics, volume 1, 2, and 3. Extensive Code of Ethics. And what does that say? So I'm just referring to the relevant provision, which for the purpose of this topic of reporting entity. And this is an old case law, which I have taken from Code of Ethics only, that if you are making investment, if you are dealing with money of the client, sorry, you cannot do it on behalf of your client. Now, and most of you would be auditors also. And again, auditing standards are applicable to all the auditors, whether secretarial, cost auditor, or a statutory auditor. All these are covered under auditing standards because they are under Companies Act. Now, what does these auditing standards says? That if there is going to be any laws and regulations applicable and there is any violation, which is going to impact the entity, then yes, you will have to make an appropriate comment in the report. So this is what already it is there from day one, and it's all, I think, almost 15 years back. This asset 250 came, maybe 16 years back. So consideration of laws and regulations was already there, and if the company was into any of the possible money laundering, possible fraud, possible violation, it has to be reported to the regulator also. So previously it was only in the audit report. Now they have added this duty that you also have to report to the regulator. And why this? Let us take an example. So ILFS case. So if a firm was auditing the ILFS company and they came to know of, let's say, the violation of the minimum fund they have to create as per the RBI circular, they have to maintain this much liquid funds. So this is a violation. So just they write it in the audit report will not be end of the story. They will have to go and report it to the regulator. Similar thing has now been included in Code of Ethics, even otherwise, NOCLAR, and it is applicable to even the employees. So if a chartered accountant is an employee also, he is not a practicing chartered accountant also, even then NOCLAR is applicable. Now what does NOCLAR says? Non-compliance of any laws and regulation, then you have to go and report to the regulator. And I think I'll just flip through this because this is non-compliance of laws and regulation. You can read. If somebody is into practice, somebody is into job, they are all included in the NOCLAR. For listed entities also it is included. Unlisted, I have given you the example. Just read this para 360 or section 360 of the Code of Ethics. It includes, if you see the second column, the second point, money laundering, terrorist financing, and proceeds of crime are included. Now, this also says, even if we are suspecting something, ultimately, even if we suspect and something doesn't come out, it's okay. We have done our duty. So even if there is a suspecting activity, you will have to report to the regulator. In fact, some of the examples which I was giving you, like suppose environment pollution, clearance has expired or not been renewed, then there is a violation of environmental law. And therefore, you have to report to the Pollution Control Board that this company is violating the law. Similar provision is there in PMLA. When we read the maintenance of record rules, there also same language is used. If we are suspecting something, if we are enabling a transaction, then we will also be part. So you need not enable that. If you suspect it, you report that transaction and don't participate in completing that transaction. That is what the law says. And I'll just share the PPT because this is all the relevant law which I have highlighted, that people tend to say, and I have seen many professionals who are senior professionals, they have their old CA Act in mind, which says that if I am being engaged by a client, I am bound by the confidentiality, I am bound by the Evidence Act, and I need not disclose these information. So, sir, there is an exception to this, and the exception is like this: if it is against law, then this Protection of Evidence Act and professional immunity will not come to your rescue. Very clearly, they have said, and I quoted this section 2.15. It says you don't have any protection under Evidence Act or any other law saying that it was during the discharge of my client-attorney relationship, because it is a crime against the state, crime against the sovereignty of the country. Therefore, you are required to disclose it. It's there in the Code of Ethics, Volume 2. I've given the citation wherever required. And I think once you will read this, it will be clear. Second point, whether I am allowed, as far as this notification is concerned, am I allowed to deal with the bank accounts of my client? Answer is no. You cannot take custody of client assets. You cannot take the control of the bank account of the client. You cannot take its money and do as you like. You cannot do it. And absolutely it's prohibited. So you can just go and read these particular sections. I'm just going to skip it and come on to some of the practical examples. So I've already told you that cryptocurrency or the virtual digital assets, they are all included in the PMLA, and it was included in FAB only. And in Feb and March, only these two things came. Virtual digital assets were included, and politically exposed persons are also now included. Now, I don't know how it will pan out, but the words used in politically exposed person circular of RBI is that senior politicians, bureaucrats, head of any political party, they all are politically exposed person. So if they are doing any transaction in an NGO, not-for-profit organization, which we have, and there is some person like this, all transactions have to be reported with respect to that person holding a position in the NGO or trust, or as the case may be. So I think it is going to be very onerous how to identify this. But in general sense, if we are having such a client who can be a member of parliament, who can be an MLA, who can be an MLC, all those things, we will have to now keep a very updated record. If we do not keep an updated record of the transactions which we are advising, and something of this nature comes up, probably we might be penalized. Then again, KYC is something which has come in under PMLA law, which was first time given by the Chartered Accountant Institute, which I could trace. I was not able to find anything like KYC for advocates. So probably now, because of PMLA law, everybody will have to maintain a KYC of their clients. And the way KYC guidelines are under maintenance of record rules, I think we will all have to buy a software to keep a video, to keep a fingerprint, and to do an Aadhaar verification of the client. I think we all will have to open a desk in our offices for doing this. I don't know how long we will be successful, but this is the law. Then real estate agents, again, precious metals, I told you CBIC, they have authorized. Real estate agent, now they have amended the definition and included it from RERA. Previously, it was from service tax law. So they keep on coming out with some notification on a daily basis. Anytime, there is no fixed interval. So we will have to go through the notification if we actually want to make this an opportunity for doing work of reporting entity. But even otherwise now, for reporting entity, we will have to keep an abreast on the notification which comes out. Then some people and some IPs also ask me whether, sir, we are covered under this reporting entity requirement. So as such, if we read the law barely, professional activity, they have included practicing CA, CS and CWA. But nowhere they have specifically said practicing insolvency professional. And therefore a catch comes whether we are involved in buying or selling of a property and we are appointed by the court, whether we would be covered or not. So this is again a food for thought for everybody to deliberate upon. So I am keeping this question open for deliberation. Just one
सर
more
इसमें एक छोटी सी बात मैं ऐड कर दूंगा, वो जो अभी पीछे थी जजमेंट आई थी ना, वेयर बाय आईपीज हैज बीन हेल्ड टू बी ए कोर्ट ऑफिसर, आई
पब्लिक
थिंक
सर्वेंट झारखंड हाईकोर्ट,
झारखंड हाईकोर्ट की, और दैट इज बीइंग फॉलोड बाय अदर हाईकोर्ट्स आल्सो. उसके चक्कर में ये आईपीएस को डेफिनेशन में एक्सक्लूड करा गया था, बिकॉज व्हेन कोर्ट हैव हेल्ड दैट वी आर द आईपीएस आर द पब्लिक सर्वेंट, perhaps that was the thought behind it. आगे यानी कि जो आपने food for thought दिया था, I am providing some spice to that.
Sir, in fact, if you read the first judgment of SRC, when both the bidders were disqualified, Numetal and ArcelorMittal both were disqualified. That NCLT Ahmedabad judgment, if you read the first judgment, because then it was taken to appeal by the NCLT and Supreme Court. So the first judgment, the 2-3 last paragraph talks about the same thing. So even the first judgment of SR Steel recognized the importance of the IP as a public servant. So that is very important that we are under the definition of public servant. But now the question comes whether as a duties discharged under the obligation of a law, whether we will also be reporting entity or not. Because the first notification of 3rd May only includes practicing CA, CS and CWA, does not include advocate. So suppose I am an advocate and I am also an IP, whether I would be falling under the notification or not, that's a question. But yes, if he's a chartered accountant and doing purchase and sale, according to my opinion, he would be included. But again, that question is open for deliberation by the panel. I'll just skip to the next. And this is again something from my own experience. So if there is an interrogation by ED and normally summons are given and we are called, we are required to cooperate and we are required to give all the possible information which we can. But again, as I've told you, relevant sections, please be sure when you are being called, under which section you are called, which notice is asked, and what all information documents are required. Please make sure that you give everything in writing, every reply or response in writing, so that you have a basis that you have done this. Second thing, and very important thing, can I take a lawyer with me if ED is giving me a summon? So answer is that yes, there are judgments, you can take advocate with you, but he can only be in a visible distance, but not in audible distance. So a lawyer can accompany the person who is being summoned, but he can sit on a stretch where he can visibly see the client, but he cannot sit with the client and answer the questions. And that audible distance should not be there. So therefore, there cannot be any physical coercion or something like this on the client. That is the main important thing which comes out from this. Then again, whenever there is any enforcement agency, there is a judgment of Supreme Court. So Bikram Singh judgment is there, which says that CCTV should be there in the complete authority, wherever you go, any investigating authority. And people have been using it in GST, income tax, and now ED also. So make sure that there are CCTVs. And if you are called and then you are appearing and then something like this, that you did not appear on a particular date, please file an RTA and get the CCTV. You are entitled to get the copy of CCTV under RTA. Nobody can stop. Third is that if there is an attachment before the auction, like normally I am handling 3-4 cases where as a liquidator, we put something on auction and there was an attachment just before a day. Sorry, if there is an attachment, you cannot proceed with the auction. You will have to fight it in the court, and the courts are like adjudicating authority under PMLA. Not NCLT, but under PMLA law, we have an adjudicating authority. Appeal from adjudicating authority goes to PMLA Appellate Tribunal, which is in Delhi. And then obviously you have Supreme Court. So, then there is a fraud circular, which says that if there is a account classification of fraud at 100 crore and above, it will go to CBI. So now in addition to that, they are also sending it to Enforcement Directorate. And one more, I'll just skip to the schedule of offenses because otherwise this will be left. So this is schedule, and this is very interesting. So part A, B, C is the schedule of offenses, that these are the schedule under which an offense will be classified. So part A, if you see, so many laws have been added. So there are, I think, around 29 different acts which have been added. Part B is of custom law and part C is for cross-border. So I am not more concerned about part B and part C, but part A is very important to us. And now, why I was saying that now in every FIR, PMLA can be there. Why I was saying so? Because of the first para 1. Para 1, if you see, Indian Penal Code, they have added. Now you see what they say in Indian Penal Code, so many sections are there. And I'm not going to read the sections because PPT would be shared. But simply, if section 420 is there, let's say there is a cheating. PMLA will get attracted automatically, parallelly. So what will happen is, there has to be two kinds of proceeding. One is predicate offense. So that is main offense. So let's say this part A is one law under which there is an offense and there is an investigation going on. PMLA can come in, so ED can jump in and again take cognizance. So two parallel proceedings. Law provides that ED can obviously move an application before the court where possibly the investigation or trial is happening to transfer it to the special court where the ED is designated to do the proceedings. But again, the law says parallel proceedings can happen. Law says parallel investigation can happen. Law says cognizance can be taken by both the authorities. So this is something very taxing. This is something going to be very difficult. And therefore, nowadays, though this law was made with an intention to curb things like terrorism and terror funding, but it has spanned out to something else. And last time I was deliberating a lecture in this tax association, they asked a very pertinent question. Sir, whether GST is covered or not. If I'm just go back to the previous slide, sorry, income tax and GST both are not covered. Because as I told you, they are black money, we can pay tax and make it white money. Now the question comes, if there is a fake billing, there is a fake billing in GST, whether an offense under PMLA is made, answer is yes. Because I told you, Indian Penal Code is attracted and then all this fraud, cheating, forgery, all these sections will be attracted. 467 is also there. 471 is there because you are doing a forgery and a fraud and therefore PMLA will kick in. So even though GST is not directly there, but it gets indirectly included. These are some of the judgments. I have just kept these judgments so that you can know how they are penalizing the reporting entity, how they are issuing monetary penalty orders, and they are also available on the website of FIU. So if you go on Financial Intelligence Unit website, you will get these particular orders. I'm not going to read because just going to skip this. So I think Manoj, I can stop here. I had just that RTI which was rejected, but I've already told that also I can share with all the participants. But again, let us some deliberate on whatever questions are there. I've already taken more time, sir.
निपुण जी, आपकी ये सारी बात सुनते सुनते मेरी तो जैकेट उतर गई। सिंपल सी रीजन ये है कि मेरे को तो लग नहीं रहा कि ऑडिटिंग प्रोफेशन आप चला सकते हैं, बिकॉज जितने ये आपने लॉज दिए हैं, कोई बिजनेसमैन ऐसा नहीं है, मेरा ही नहीं, हर किसी का क्लाइंट ऐसा नहीं है जो इनमें से किसी एक का वायलेशन ना करता हो। पहली बात। दूसरी बात कि हर किसी को कहीं ना कहीं से कुछ ना कुछ नोटिस आया होता है, मेनी टाइम्स वो आपको बताता ही नहीं है। आप उसको डिग करने की कोशिश करो तब भी नहीं वो बताता। आई रिमेम्बर, मैं एक बड़ा क्रिटिकल सा एग्जांपल देता हूँ, उसका जरा सोल्यूशन भी मेरे को बता देना। मेरे एक क्लाइंट को पीएमएलए का नोटिस आ गया, तो मैंने उस साल की बैलेंस शीट के अंदर उसको डिस्क्लोज कर दिया और पहले नोट्स अकाउंट्स में डाल दिया, फिर बाद में मैंने क्या कहते हैं अपनी रिपोर्ट के अंदर भी कह दिया कि ये मटेरियल है। तो जो हमारा एक्सप्रेशन ऑफ सॉरी वो जो हमारा एक आता है ना क्वालिफिकेशन ऑफ रिपोर्ट, उसके अंदर मैंने डाल दिया। लेकिन अब मेरे को लग रहा है कि मैंने बहुत भारी गलती करी, मेरे को कंसर्न अथॉरिटी को भी बताना चाहिए था। आई वाज रिमेम्बरिंग इट कि बताना चाहिए था। जब भी मैंने कोड ऑफ एथिक्स के अपने इंस्टीट्यूट का पढ़े थे तो उसके अंदर दिया हुआ था, लेकिन याद नहीं रहता ना उस समय, पहली बात। अब उसके बाद हुआ ये कि सुप्रीम कोर्ट ने पीएमएलए के प्रेजेंट की जो प्रायर नोटिस थे एक पर्टिकुलर डेट से, उनको उन्होंने स्ट्रक डाउन कर दिया। तो माय क्लाइंट वाज गेट कवर्ड इन दैट पर्टिकुलर थिंग आल्सो। तभी तक उसके ही इज फाइटिंग विद दिस थिंग एंड ही हैज टेकन ह्यूज लोन फ्रॉम द बैंक्स आल्सो। वो मेरे पे इतना प्रेशर डाल रहा है इस पॉइंट को 23 वाली बैलेंस शीट के अंदर ना डालने का। कह रहा थी हमारे बैंक वाले तो एकदम ये पॉइंट देख के उछल जाते हैं, ये है वो है, दे स्टार्ट डाउनग्रेडिंग आर दिस थिंग लाइक दैट करने में। तो व्हाट आई मीन टू से इज दैट कि पीपल हु आर लिटिल बिट सीनियर लाइक अस, it's a hell of a job to do the audit nowadays. And as far as जो आपने पार्ट ए का था हमारे को बताया कि इतने ऑफेंसेस इसके अंदर प्रैक्टिकली यू कांट डू इट। फीस तो मिलती नहीं काम करने की। ऑडिट आप कर दो 6 महीने जा, अगले साल वो रोते रहो, तब जाके अगले साल फीस आती है जब नेक्स्ट ईयर की बैलेंस शीट साइन करने को आती है। सेम अमित जी you might be also having experience of doing company secretary practice, because you people are more involved with corporate world. We are also involved, but you people are absolutely and exclusively involved with the corporate world. और corporate world के अंदर बगैर offense के या बगैर उसके मेरे को तो लगता है किसी का धंधा चलता होगा. This is what my perception is of most of the businessmen. Please deliberate on you also and ask some questions as per your as you want.
So thank you, Nipunji. I think I have a little contrary view than what Manojji is having. I think all the professionals were having a lot of clouds in the mind after reading the notification of May 3rd and May 9th, 2023. But the way Nipunji has clarified the issues with regard to the PMLA in the today's deliberation, it was so fluid, it was so lucid that I could not dare to interrupt in between, so that the fluidness should not be stopped. Now that was the reason, and I think it has answered majority of the questions, at least which were in my mind, and I'm sure it would have answered the questions which are in the mind of the professionals also. But still, I'll request the professionals who are still there to put their questions in the chat box, or maybe we may also allow you to unmute and ask the question directly to Nipunji. But meanwhile, you do. I have just one small doubt or other analysis what you have done beautifully. So as you are saying, and you have been emphasizing that whatever activities are covered or intended to be covered by 3rd May 2023 notification by a professional, by and large are restricted by the code of ethics. If they are so, then I'm just trying to understand, means A, the intention could be that maybe it is restricted by the code of ethics, but some person may breach the code of ethics and still do so. So you are not only liable for the breach of code of ethics of the respective institute, but you will also be liable under PMLA. That is one. B, that you cannot do at all, and there is only very limited amount of transaction which can be undertaken perhaps by a chartered accountant or a communicatory or a cost accountant, as are intended to be covered, which satisfies the requirement which is basic, that is the proceeds of crime, where the PMLA has an intention like you do the parking, then you do the layering, where you are involved in any of these activities. Let us take the example, you quoted very nice example of a Chinese company. Let us say Manojji gets a mandate for incorporating some 100 shell companies in India. I'm taking just example for sake of understanding. And now Manojji involves some professionals all across. Each professional, he gives a mandate, boss, you incorporate 10 companies. And when we professional ask him, ki, sir, you kindly tell us the name of the director and shareholder, he says, ki, boss, you don't worry, you keep your staff itself as a director and shareholder. And also you keep your own registered office as the registered office of the company. You don't bother about the money. We'll pay you 50,000 rupees for each incorporation. That's it. Is the intention of law where the mandate is to pass the proceeds of crime through these 100 shell companies, is the intention limited to these kind of crimes where the professionals can be captured and covered, or the first option that I mentioned, is the intention that also? I would like to hear your thoughts.
Sir, you have actually hit the nail on the head. You are absolutely right. And in fact, we got bail for professionals in 2 of such companies, wherein they had incorporated in one of the case, and again, it's a Gujarat example, one of the case, and the professional themselves was a part of the delegation of Mr. Modi in Vibrant Gujarat. That also I must tell you. They incorporated a company, a Chinese company, made available their own office as a rented premise. So rented premise of registered office of the company was the same as that of professional. Number one. Number two, Chinese directors were not inducted while incorporating. Local people were taken and thereafter Chinese were added. And then obviously the local people got retired. Now the ED has been questioning and ROC filed an FIR. Both things had happened parallelly. And they questioned that why there was a nexus. What is the nexus of a Chinese person in Indian company? Because you incorporate a company normally with 1 lakh and thereafter they bring funds and all those FEMA compliance and everything happens. So this particular investigation led to a place where we actually had to go and take a bail, because otherwise that professional would be left high and dry and they will obviously get a very meager or a peanut fee. So you are absolutely right. Now we have to be doubly vigilant. And in fact, I tell you, we are not even vigilant to the clients who are locally available. How can we be vigilant of the clients who are coming from overseas? When nowadays we do not have any access to get even the passport verified. I tell very specifically. They ask us, like Manojji also in one of the program we were discussing, how can I verify, let's say 29A list of maybe willful defaulter, maybe fraud list? Is it available publicly? No. So when they are casting a responsibility, my view is, and in fact, I have told many professional forums and institute also to talk with government, get in dialogue and say that you at least provide us the access. How can we verify somebody is genuine or ingenuine? Today, if I make a foreign national company or maybe a company coming from China, you were taking funding for, let's say, 9 years, 10 years, and today you are saying it's a fraud. How it is possible that for 10 years, all the authorities were sleeping and just the professional who is incorporated, now you are keeping that person behind the bar? So it is absolutely incorrect. And I understand that these provisions are onerous, but yes, our professional institutes will have to take a call, get into dialogue and bring about some mechanism where we can verify things. Because I am sure no professional would knowingly take a risk to create a bogus company. Never ever will a professional try, because if he's a genuine professional, he knows what would be his risk. Risk should be limited to the fee he's charging, not much more than that, what he is charging. So, sir, you are absolutely right, and I agree. And this is obviously a place where we all need to voice our concern and take it to the authorities that we get something. When we are loaded with the responsibility, at least we should have some rights also.
All right. I think let me take some more questions if we are posted with. Tarunji is saying if we are providing these activities not in the professional capacity or in discharge of the professional duties, whether we are covered or not. So Nipunji, he's asking that where we are not doing in our professional capacity, right? Maybe I am though by profession a communicatory, but tomorrow I cease to be the practicing professional. I provide these services in other capacity, whether I would be covered or not. So I think you have answered very well in the earlier slides also. You referred to the section 54, wherein even if a person, even prior to these amendments, the other peoples are also covered. So the enforcement directorate can very well reach out to any person. It does not really matter whether you are a professional or not. Specific inclusion is for giving a focus. I think that is nothing else. The inclusion notification of May 3rd was only to give an indication and to meet certain obligations. I think there is a delegation which is going to come in November 2023 in India for verification and doing the research on this FATF validations in India. For that purpose, these notifications are released. Otherwise, the recommendations are way back, a very long time back. These recommendations were made. India took, I think, more than a decade to implement all these implementations. I don't think there is any other intention, but if Nipunji, you have any other thought, you can please share.
Sir, you are absolutely right. I agree with what you said, sir. Absolutely. We can take the next question.
अभी
I
जी
don't,
टाइम काफी
I
हो
think-
गया है, 4:45 हो गए. प्लीज गो फॉर द क्लोजिंग रिमार्क्स.
Yeah, I think there are no more questions also, and the deliberations made by Nikunji were so very exhaustive and lucid that they had covered majority of the questions. And in any case, we will take a privilege of inviting him again, specifically for a question answer session, wherein because this was a precursor where we have understood the concepts and the length and breadth of PMLA. And in next session, I think there will be more questions. So thank you, Nipunji, for giving such a exhaustive canvas for thinking on the PMLA and reducing the strain also, I'll say, to some extent that was causing a burden on the professional's mind, that these two notifications of 3rd May and 9th May has caused to the professionals. I think now we had a sight of relief also, although we are becoming more aware as to responsibilities towards the reporting entity and doing our duties. I think it will help all of us. So from IPA, I extend our gratitude for you to spare valuable time from your schedule. I know you are very busy in your professional assignment, but you are always available for the cause of the profession. That's the beauty. So thank you indeed. Mamta ma'am has also joined, and I would request if she want to say parting remarks.
No, thank you so much, Nipunji. I was there. I joined a little late. Actually, there was something pressing, very, very pressing. Otherwise, IPA is the most important thing that we have in our agenda. And let me tell you, Nipunji, I must inform everyone, it's with one small request that we made, and he was absolutely, so willing and ready to take up this session. Nipunji is, of course, his knowledge is par excellence, but as a human being also, I think he's a very, very nice person. A person with whom all will be very happy to get associated with. Thanks, Nipunji, for your valuable time. I'm sure the whole thing is actually playing a lot of rigmarole in our minds. What Manojji mentioned, I totally can resonate. And that, we as professionals are really now in the doldrum as to what to do exactly. Where are we going wrong? What is it that have we done wrong? We are always so very careful in whatever activity or assignment that we are into. And why is it that this sword is always hanging in our neck, in our head? This concept of always keeping oneself intimidated is something which is, I think, very heaviness that has been entrusted upon. And no one is liking it. We all like to work, but in a tension mahol, I think it becomes very difficult. I think gone are the days when, as professionals, we used to enjoy what we were doing, what we are doing. Nowadays, somewhere or the other, we've stopped enjoying. We think that we just need to do it. What else can we do it? Because we've been always involved in books and papers and documents. We can't go ahead and start an industry. But somewhere or the other, I've always felt that the index of happiness amongst professionals in doing the work is going down. I'm sure things will look up because चलती का नाम गाड़ी तो है ही, बस उसके अलावा रोशनी जो टनल के एंड में दिखती रहती है वो हमेशा लगता है वो रोशनी बड़ी होगी, छोटी नहीं होगी. तो in this hour of understanding, Nipunji, you've really stood tall and you've been educating all of us, not only in this session, but in so many different ways you're doing it. And I must say, I'm a big admirer of our own very president, Mr. Manoj Anand, who beautifully gives these updates that he does in every meeting. We all look forward to what he has in store in his goodie bag whenever he comes up for updates. And I think all of us have been putting that into commercial use. So thank you, Manojji. And at the end, I must thank Amitji, who really took out time and gave his valuable time and effort to IPA.
My pleasure.
And from all of our sides, and today even from the side of Nipunji, if I can include him too, we will request all of you to please become member of IPA. strengthen this body, because this is your body. This is nobody else's association. It is an association for us, by us. And I'm sure it will go a long way if all of us join our hands together. Manuji must have spoken about all of you to subscribe for our membership. We also humbly request that please come forward and be as members of IPA.
एक्चुअली ममता जी का बात को हम आगे एक्सटेंड कर रहा हूँ। अमित जी एक सेकेंड, वो देखिए जो इंडेक्स ऑफ हैप्पीनेस है ना, ये हमारे आईपी प्रोफेशन के अंदर भी बहुत बुरी तरह से डिक्लाइन हो रहा है, स्पेशली विद द काइंड ऑफ डीसी केसेस व्हिच आर कमिंग आउट टू बी देयर। जैसे एक मैं बड़ा अच्छा लाइव सा एग्जांपल दे रहा हूँ। एक पर्टिकुलर आईपी को ईआर ने अपने एक्स्ट्रा काम करने की एक्स्ट्रा फीस ले ली, उसके लिए डीसी ने उसको नोटिस दे दिया। और अभी जो ये पेपर डिस्कशन पेपर आया है, इसके अंदर आईबीपीआई खुद ही उस फीस को प्रपोज कर रही है कि लेट ईआर बी अलाउड टू चार्ज फीस लाइक दैट ओनली। So you know we are living in a very vibrant world. और as far as our auditing is concerned, मैं सीए ब्रदर्स के साथ शेयर करना चाहूंगा कि हमारे यहाँ पे कोड ऑफ एथिक्स इतना इंपॉर्टेंट हो गया है कि हमारे यहाँ पे जो सीपीआर है ना, उसके अंदर आई थिंक 3 या 4 घंटे आपको सिर्फ कोड ऑफ एथिक्स के ऊपर लेने पड़ते हैं। आई एम नॉट वेयर ऑफ दैट थिंग इन कंपनी सेक्रेटरी और सीएमए, बट हमारे सीएमए स्पेशली उन्होंने डाला कि 3 घंटे आपको कोड ऑफ एथिक्स ही पढ़ के लेने पड़ते हैं। और होता यह है कि वो जब फैगट आता है 31 दिसंबर का, तो तब इसकी क्लासेस हर वेबिनार और उसके अंदर स्टार्ट हो जाती है। बट इन एनी केस I extend my the talk of निपुण जी। बहुत Amit ji may be differing with me, but it has become very difficult. Now people like us जो कि पिछले 25-30 सालों से कुछ क्लाइंट्स को मेंटेन करते हुए आ रहे हैं, either as a teacher or as a corporate consultant or a corporate certifier like company secretaries, to answer their queries. To answer their queries mean comply with the laws. आप किसी अच्छी कंपनी की आप ऑडिट रिपोर्ट को क्वालिफाई करने के लिए जाओ, आप इतना प्रेशर पड़ता है आपके ऊपर, इतना प्रेशर पड़ता है। आई थिंक द सेम शुड हैव बीन विद द कंपनी सेक्रेटरीज आल्सो व्हेनेवर दे बी गोइंग फॉर सेक्रेटरी कंप्लायंस एंड ऑल दिस थिंग्स। प्रैक्टिकली कितने लोग इतना अच्छा सेक्रेटरी कंप्लायंस कर पाते हैं जितना कि हमारी इंस्टीट्यूट हमारे से एक्सपेक्ट करती है। एट द एंड ऑफ द डे व्हाट हैपेंस that we know there everybody, लेकिन बाई चांस गलती से कुछ किसी चाइनीज कंपनी का झमेला आपके सिर पे पड़ गया तो पूरी you think of a situation। अब हम लोग हैं 50 साल से लेके 60 साल के बीच में, एक हल्की सी आपने गलती कर दी और आपको दिल्ली में तो तिहाड़ जेल है, पता नहीं कैलकाटा और लखनऊ में और हैदराबाद में कौन सी जेल होगी, कोई आपको वहां पहुंचा दे और कितना you feel so bad about it। इवन आईबीपीआई से अगर किसी का नहीं, डरते तो नहीं, हम डरते होते थे, बट यू हैव अ कॉर्टेसी इन माइंड। एक अब मैं आपको बताता हूँ, वी बीइंग द प्रेसिडेंट ऑफ द इंस्टीट्यूट एंड ममता जी सेक्रेटरी ऑफ द इंस्टीट्यूट, किसी को भी डीसी का नोटिस आता है ना आईबीपीआई से, और सबसे पहले हम लोगों को फोन करता है। उसका पता पहला क्वेश्चन क्या होता है, एसोसिएशन क्या कर रही है इसलिए व्हाट एसोसिएशन इज डूइंग दिस थिंग। तो वरीज आर देयर। अगर हम ये कहें कि वरीज नहीं है, वरीज आर देयर। happiness index is downing। और तीसरी बात ये आ रही है, no doubt our economy is growing, our economy is the fastest growing economy, but still competition is also creeping up। जो हम लोगों ने ममता जी एंड अमित जी यू विल रिमेम्बर कि 2007 या 2008 सॉरी 17-18 के अंदर जब शुरू में आईबीपीआई आया था, ममता वाज द नेम ऑफ एवरी स्ट्रीट जब उन्होंने पहला केस सेंट्रल करा था सरोजी डोले का। तो आज की डेट में आप देख लो, आज की डेट में सो मेनी प्रोफेशनल्स आर कमिंग देयर। बहुत सारे लोग ये हमारे को कंप्लेन करते हैं कि 4,500-5 हजार प्रोफेशनल्स हैं आईपीज आज की डेट में, हार्डली 1000 बंदों के पास काम है, 2,500 से 3,000 बंदों के पास एक असाइनमेंट भी नहीं आई। And passing an IP exam is not easy, that we all know, and especially with the day by day it is becoming difficult and difficult। In any case, शायद हमारी ट्रेनिंग ऐसी है कि we love to live with all these hurdles। We have a जितने मर्जी हो, कहते हैं ना कि ओले सिर पे पड़ दें तो कोई फर्क नहीं पड़ता। We love to have it। हमारे साथ निपुण जी जैसे बड़े भाई हैं जो लगता है कि कब भी कुछ होगा सेब बचा लेंगे हमारे को, ममता जी जैसे मोटिवेटिंग फैक्टर हैं, और अमित जी जैसे लोग हमारे साथ हैं जो you are always smiling under all these circumstances। With these words, Thank you very much. Thanks to all my participants, especially to Mr. Akhil, Mr. Srinivas, Mr. Maheshwari, Mr. Deepak, and Mr. Meshwara also, who were quite visible on that video. And thank you, Akhil ji. You've been with us for since beginning. And again, मैं वही बात करूँगा, just to give encouragement to all the governing body members. Do join our membership. I think 15 June is the last date. We have been able to enter, make some very senior politicians as our member also, looking for some MC officers also. Thank you very much. Do join us. Thank you very much. Do encourage us by attending our webinars and by joining us. Thank you very much.
Thank you very much, sir.
Thank you.
Thank you, Amit ji. Thank you, Mamta ji. Thank you, Manoj ji,
My
for
pleasure.
inviting me and allowing me to give my deliberation. Thank you.